Sorry. It's not my last kind of permission after. I think when you also both matters versus bishops of the matters. Lordship and directed to listed today. But the problem is that it's not been listed. Now the problem is they have now started in implementing the order where the order has not been passed. In which case the order has not passed. Implementing. Yes, today, yesterday you have to see that they are going for the election. And they have already, so far the accounts are concerned that account is being transferred in favor of the video and other things. Person look to that. That is the last yesterday's results.
I'm trying to steamroll all opposition, steamroll all resistance, despite the fact that
same order of the past, everything is in the past. I did, but of course,
despite the fact that
the election that is because of that impugned order, and the next one also the impugned order.
Lordship have already expressed their Lordship's mind that even if there is a come to court should get the protection. But
those who are
question of policy, so but tomorrow
But Saturday also the judge is coming.
Tomorrow, so that at least protection screens. Yes. We have to take this at least.
Similar thing. Put up Saturday. Yes, Saturday.
I beg your lordship's party gratuity matter, my lord. We think as a proceeding of society, the gratuity has the health of my lord. I will return of my party. Yes, restaurant. Yeah. Restaurant.
What is the urgency?
Yes, matter, your lordship, the connecting matters are ready for you. Affected, so that.
Transfer matter. Also, in this case, just no direct taking instruction state council no notice has been issued. Now, order of control call the activity. Even the continuous status code now they have issued interest for the handing over the charges.
Monday.
Maybe part of the victims. Yeah. After notice matter was specifically adjourned the 12th of August, my application seeking permission to sell my ultrasound machine has been rejected.
Immediately after vacation.
Right. Before vacation,
no, very much. Item 60. Item 60, last item in the hearing. I learned that appealing for the opposite party.
Objecting, my lord.
Here, given me affidavit, challenge my qualification once he opposes. Only you can make motion when matter reaches. Yes. The affidavit. Let it. I will never want to be part of it. No, that I will be part of it. No, what's present? Fresh admissions. Application.
My lord,
Any urgency? Any urgency?
My lord, I beg your lordship's pardon, my lord.
Brother has requested me to make the welfare. Impossible.
No, any urgency?
Possible tomorrow.
Very urgency, Mr. What is the urgency? Urgency क्या है? जरूरत क्या है? थोड़ा हिंदी में नहीं.
The matter relates to land acquisition, man.
Land acquisition. Let it come immediately.
My lord, I beg your lordship's pardon.
And the relates to add safety rules matters. Have been taken after affidavits in by region 45 action
Immediately. Inform other states.
Item 21, your lordship. Item 21.
Yes.
Permitted to withdraw will be equity. That application, because my lord, on filing of this case, subsequent developments come to the notice of the petitioner.
Okay.
Yes, sir. Serial number 21. Learned consent for the petitioner has moved a memo seeking to leave to withdraw the petition. First of memo reads as that. First of in view of the above, petition is disposed of as having been withdrawn with liberty as sought upon.
Yes, sir. The opposite cancel my eligibility. Any moment equals me outside regarding there.
Yeah, when it was cancelled.
Then get back to knowledge.
That's all. When it was cancelled.
Yes, sir.
Activity.
Matter, cover matter, any date you also, a date family, you cover matter on this level. Cover by just cover. This on level.
Immediate application we can have that.
The nickel.
Yes. On 9th.
My lord, I beg your lordship's pardon.
Only I filed a rate application that was pointed to file some matter particular. Accordingly, I have filed 2 weeks before. Next week,
Next week we have many matters. Next week what I have decided is only urgent matters will be because court will be working only for 1 week.
if I am reinstated and get salary for
Oh, within 1 week. In the case and the it's same day it is not of one chance.
Maybe please your lordship, the serial number 212 manner in the weekly list manner. That is covered matter. Already your lordship, the last week manner, already you have decided the matter. So far as the reserved senior category candidate can be considered against the unreserved vacancies for promotion matter. Already decided manner. That case can be withdrawn to do.
Let us see. Which year, man?
My lord,
But many 2009.
The matter already decided. Your lordship has been decided.
my lord, I beg your lordship's pardon, my lord.
Restructuring of Panchayat mission in secret pension. That is the request. Then is the support of the issue of license supplement. It's checked in Bharat, sir.
My lord, I beg your lordship's pardon.
Another matter, promotion matter,
Immediate.
My lord, I beg your lordship's pardon. My lord, I have filed a memo, my lord, where a teacher has claimed for his revised retirement benefits, and it was specifically adjourned to 8th of September, but not listed. So, my lord, he has retired since 2012, and similarly situated got the benefit. But my lord, my matter has, I am not getting that benefit. It's a revised retirement pension matter. May I pray, my lord, in this week? I have given a memo.
Yes, immediate. Yes.
My lord,
Yes.
my lord, review petition of the year 2023, my lord. It is I have filed e-filing memo, my lord, twice, but it has not been listed, my lord.
It will be listed on application. Give them.
The list item 1.
Yes.
illegal and arbitrary order of rejection.
Make best use of the mic. Make use of the mic. That helps you. Yes. Then,
Illegal and arbitrary order of rejection on the allotment of residential block. With the establishment of Raukala.
the illegal allotment.
Madam,
You have challenged illegal allotment to other person or to you.
my ancestral property
It is allotted to him.
in my favor, in my father's favor.
Thereafter, what happened?
So application was made without affording any opportunity of being heard. My application was rejected. It plays true. And it's enlisted to me.
It is your own property
No.
because acquired
It was acquired.
from your ancestors.
I may be permitted to place that rejection order to very small order.
Okay.
On subsequent decision of the land allotment at page 8 minor,
Correct.
in excess to
Yes.
on
Meeting dated
subsequent
24
decision of the land allotment committee, meeting dated 24/12/1996. After due verification of the record documents, your application hearing number such and such for allotment of residential plot
plot in the area number 7 and 8 of Rautla Civil Township has been rejected by the land allotted committee on the ground noted below.
That you own 0.112 in khata number.
My lord, as per the report of the additional Tahsildar Rautla,
Yeah.
an area of
What? 0.1.
112 in khata number 295, town unit, etc., recorded in the name of your father.
Yeah.
This much is the case, without affording any opportunity of being heard.
Now, whether this is false or true, the reason given here, is it false or is it true or that it's incorrect? Correct? What is that?
If I counter,
Yeah.
it's para 5 of the counters.
I'm asking you whether this fact is true or not.
This fact is true.
Then what way you should
But then no land has been allotted to me, though it is not traceable. Without affording any opportunity of being heard.
What is that being heard? Your father is owning land.
Because before passing any order,
No, that is not the law. That was the law about 50 years ago.
Yes, my lord, that passed the order after 5 years.
That's all right. Then the fact, do you dispute the fact that your father owns the land? Okay.
That is an ancestral property of mine.
You are entitled to a share in the property. If those who are having share in the property are not entitled to allotment, that is the reasoning. Which are the allotment rules? Show them.
The allotment letter is not with me, but only my lord I can say that para 5 of the counter, they have mentioned everything.
Yes, wait.
That with regard to the fact and awareness, my lord got it.
I am giving attention, full attention to you. I need not read. I remember whatever you read. I will reproduce it also. Yes.
With regard to the facts and circumstances made in paragraph 5 and 6 of the writ application, it is humbly submitted by the deponent that the lead application form number 1950 was filed by the petitioner as category 1 on 7/1/92 for allotment of residential plot in area number 7 and 8 of Rautla Civil Township in response of the notification number such and such dated such and such issued for the purpose. The said application was placed before the land allotment committee, which was held on 2/7/93, 3/7/93 and 31/7/93, along with valid application for allotment of land in an area number 7 and 8 of Rautla Civil Township. It has been decided that if any allottee or allottees are found to be ineligible or have suppressed information particular or submitted false certificate, affidavits, etc., the allotment would be cancelled. It was further decided by the land allotment committee that the allottee will have to file press affidavit indicating that they do not have any land or building in Rautla Civil Township area, either in their name or in the name of their family member. The opposite party number 1 had been authorized by the land allotment committee to make verification of the allegations with reference to the records of the Tahsildar, Housing Board, Rautla Development Authority, Rautla. The application of the petitioner along with the report.
What they say, I have read it fully. What they say is, they declare 0.112 in khata number 995, TU number 35 recorded in the name of his father, your father. Therefore, they say, already family is having ancestral property. The allotment is meant for those who do not have land, therefore rejected. What is wrong with that order? That's why Apex Court has said.
Will I, you also permit me to submit?
Yes.
Here the problem is not whether my father is having or not. It's also, we have not filed a rejoinder, unfortunately. That is because we entered into this in 2019. In any case, first time it is being listed after 25 years. Now my question is, Your Lordship, that before rejection of my application,
Listed for the first time. It was dismissed earlier.
yes, dismissed earlier, after a long time, up to 2019, after our appearance, listed now. So, my lord, what I want to submit, my lord, had an opportunity being granted of what before cancellation of that.
He agrees that yes, this land belongs to ancestral property is my father. What else is what further you should be heard in the matter?
Before rejection,
Yeah.
it is been noted here, my lord, by the previous lawyer or someone I don't know. On verification of such they are not found in Bhulek. Bhulek, there is a website, Your Lordship knows. My lord. Totally false to say my father having no such khata area is specified where is the plot number. There is no plot number. So this is what I mean. No, I have not finally rejoined.
Where is the rejoinder?
Rejoinder. Rejoinder was not there. So what am I only
The
something
short grievance of the petition
Go back to
is
the-
against the rejection of the land allotment.
election
First, the said order is that lately so and so I connected to. First, it being too short and too sweet also is reproduced for easy reference. First, next paragraph. Learned counsel from the petitioner vehemently argues, learned senior advocate, Mr. Sarangi senior vehemently argues, the rejection is sans an opportunity of hearing and therefore is violative of the first. When asked as to whether the contents of the second part of the impugned order is due, very fairly, the counsel on record says in the affirmative, answers in the affirmative. First, next paragraph. The specific contention at paragraph 5 of the counter taken up by the other side reads as next paragraph. Next. Having heard the counsel from the party and having perused the petition, this court declines indulgence in the matter, inasmuch as hearing would not have changed the fact matrix that the land admeasuring 0.112 acre, Akka number 995, PU number 35 is recorded in the name of applicant's petitioner's father. What? First, the principles of natural justice cannot be chanted like Vedic mantra. First, the system has moved from ritualistic adherence to consequential factors of violation of principles of natural justice. First, that being the position. This view gains support from the decision of Apex Court in S.L. Kapoor versus so and so 19. Just look into that. So, first, in the above circumstances, petition being thoroughly devoid of merits is liable to be and accordingly is dismissed. Yes. Next. Yes, and of course, judgment. AR 1981 AC 1981, sorry, 1981 SCR 1746. Next. Annexure 5. What is that?
And the fact of the case is that the petitioner was a criminal case was initiated against the petitioner.
Make use of the mic. Your case and voice both are weak. Case is also weak. Adjust. Make use of the mic. At least by your voice you can increase by sometimes increasing decibels will enhance the merits of the case. Yes.
You have to protect one criminal case initiated against the petitioner. I'm the school teacher, man.
He was a primary school teacher.
And one criminal case was initiated.
What under which section?
376, man. 376.
This
376 and
376.
not only. Petitioner was acquitted, man.
Equity.
Petitioner was acquitted. In the year 15.
Well, case number is date number, give me. I understand. GR case number 598. I mean 1985-40. 598 of 2040. And GR number 23/40. You have been acquitted on which date? Date of the order is 10 to 15. 10 February 2015. Any disciplinary inquiry was held against you?
At the same time, one departmental proceeding was initiated against the petitioner, and he was dismissed from the service by against 2 months.
Dismissed on? (19/9/2014). Yes.
Section. He approached the independent. He was not considered by some parties, and lastly, he has been infringed something.
You are a teacher. You were involved in a rape case. Though you are acquitted, disciplinary inquiry is held. You are found guilty. How that acquittal in the criminal case will come to your claim?
Criminal trial, even a criminal trial was made, he was acquitted from the criminal case. Our departmental at that time proved proceedings were initiated. One criminal and departmental
Both are permissible.
What? In criminal case was proved that he acquitted.
A school teacher who was involved in a rape charge punishable under section 376 of erstwhile IPC 1860 and who has been dismissed from service by disciplinary inquiry order dated 19/9/2014 is knocking at the doors of this court, essentially seeking a direction for setting aside the dismissal and a consequential reinstatement in service on the ground that he has been granted acquittal of the full-fledged trial in GR case number 598 of 2014, decided on 10 February 2015. First time. Learned counsel, next paragraph. Learned counsel from the petitioner vehemently argues that the impugned order of dismissal is wrong because his client has been acquitted in the criminal case, and secondly, the parallel proceedings, namely one DE and another criminal case, could not have been proceeded at a time to his prejudice. Mr. G, do you have anything to say?
No.
Next.
Once such a teacher should not be there in service after commission.
The AGA appearing for the AGA, Mr. G, appearing for the OPs, opposes the petition on the ground that it is always permissible to hold parallel proceedings of the kind in the light of apex court decision, which is that famous judgment. Paul Anthony
versus Bharat Gold Mines. Bharat Gold Mines
versus Bharat Gold Mines. And secondly, what happens in criminal case is irrelevant. Especially, I agree with this submission. First, he also rightly says that when a teacher is dismissed from service on the ground of a misconduct involving high moral turpitude like rape, such a person cannot be continued as a teacher. And that would give a very wrong impression to the children and to their parents. First of all, there is a lot of force in this submission too. First, next up, in the above circumstances, petition being thoroughly devoid of merits is liable to be and accordingly rejected. Courts having been reluctantly made easy. Next. Item 3.
May please, your lordships. One of your lordships have passed similar cases. Yes.
Ji, can we make that order?
Yes.
Yes.
Yesterday, your lordship have passed.
Yes.
Item 4.
Yes, sister.
My lord, this writ application is filed.
You have to increase your decibel levels.
Pardon me.
Yes.
This writ application is filed seeking a direction from the opposite parties to issue a legal certificate in their favor, my lord. On 9/7/2023, we first gave an application.
9/7/23.
2023. Yes,
You have given it to whom?
The Tahsildar, opposite party number 3, my lord. Again, on 7/3/2025, a further application was given. The time limit for issuing the certificate was till 22/4/2025.
22/4/25.
Yes, my lord.
Taking second application.
Yes, my lord.
How many days it is?
30 days. Generally, the time limit is of 30 days. That is envisaged under rule number.
No order is made.
No order is made.
Is there deemed a conferment of certificate?
Pardon, my lord?
Deeming provision is there.
Yes, my lord. There is a provision under Rule 5 and 6 of the Odisha Miscellaneous Certificate.
Saying, read. You read it so that many others will be knowing.
Rule 5 says, institution of case and inquiry. The revenue officer shall initiate a case record, scrutinize the documents furnished by the applicant, verify the relevant records, if any, in the office, and wherever necessary, may himself inquire into the matter or call for a report of inquiry by a specified date from an officer subordinate in rank. Further in 6, it says order of the application. They are to pass a necessary order after the scrutinization of those documents, my lord.
Mr. G, let them take a call.
Take a decision, my lord. Lordship may direct.
Yeah. The short grievance of the petitioner is as to non-consideration of his application. One or two?
Two petitioners.
Two petitioner. Their application dated 19/7/2023 and subsequent application dated 7/3/2025, wherein they have sought for issuance of heirship certificate. What is that?
Legal heir certificate.
Legal heir certificate. In terms of rules?
Rules 5 and 6 of...
in terms of rules 5 and 6 of?
The Odisha Miscellaneous Certificate Rules, 1984.
Signed, so
Much better to
rule
1984,
1984.
amended on 2017.
Learned counsel for the petitioner submits that the rules grant a legal right to apply for and obtain legal heirship certificate, and when such an application is made, the authority, namely the OP Tahsildar, cannot keep it pending indefinitely. First off, there is prima facie force in this submission. First off, next paragraph. Learned AGA Mr. G, in his usual fairness, submits that he would instruct OP number
3, my lord.
OP number 3 to look into the subject applications in accordance with law and in a reasonable time. First off, he deviates that all contentions of the party should be kept open so that a decision on merit should be taken uninfluenced by extraneous matters. First, with this proposal, counsel for the petitioner is agreeable. Next, in the above circumstances, the petition is disposed of. Time for compliance is 8 weeks, which would include conveying the result of consideration of the subject applications to the petitioners in writing. First, all contentions are kept open. It's open to OP number OP Tahsildar to solicit any information, document, etc., etc. Now, no cards. Next.
Deeply obliged, my lord. Item 5. May I please, my lord?
Yes, please.
Petitioner joined as a teacher in the year 1999. He took permission of the authority and
Trained graduate scale.
yes, his prayer is to disburse the trained graduate scale from the date he obtained the degree, my lord. And the
Representation is dated 18 February.
my lord.
We'll direct them to consider the representation.
My
Who
lord.
are the respondent? Mr. G appears to be Buckley. The short grievance of the petitioner, as has been aired in the representation dated 18 February 2025 at Annexure 10,
My lord.
is as to non-fixation of pay of trained graduate scale with effect from
My lord, 14th February 2011.
14 February 2011. First time. Learned counsel for the petitioner submits that the foundational facts on which the right to get the subject pay scale are stated in the representation with meticulous details, and despite that, no decision is taken on the same, nor there is any possibility, nor there is any hope that the application would be considered in the near future. First time. Next paragraph. Learned the AGA, Mr. G, appearing for the OP number 3. OPs. Very fairly submit that you would instruct OP number 3.
OP 3.
3 to look into the grievance of the petitioner in a time-bound way and in accordance with law, if all contentions are kept open. First of all, this is appreciable. Next paragraph. In the above circumstances, petition is disposed of, prescribing a period of 8 weeks for disposal of, for consideration of the subject representation and to inform result thereof to the petitioner in writing. First of all, at this stage, no, in this case, no, of course. Yes.
Item 6.
6.
May I please?
Yes, sir.
The petitioner challenging the impugned order 29/5/2025, that is Annexure 4, passed by the sub-collector Balesar in Miss Appeal number 67 of 2025, set aside the legal aid certificate of the petitioner, my lord. This is Annexure 4.
You had sought for setting aside legal aid certificate.
Yes, my lord.
It was granted to the other side.
Other side.
OP number 3 has set aside it. They refused to set aside.
OP number 5.
5. No appeal, revision, no further appeal, anything on this.
Appeal he has preferred.
Okay.
It was sub-collector Baleshwar is the appellate authority. He has preferred appeal.
Thereafter, no remedy.
Thereafter,
Departmental level.
No, he has disposed of the appeal.
That's the end of the matter.
Yes.
What is the defect in the order?
My lord, on the date, the kind of last page 28, my lord.
28.
28, page, Annexure 4. Advocate for the appellant filed Hajira. Appellant is the present.
Hajira means?
5. Hajira. Advocate for the respondent 2 and 3.
Appeal.
And file time petition. The time is not allowed. In the first time appeared, my lord, without giving any opportunity, without filing any objection, the first time set aside, my lord. My humble submission, my lordship, may remand it back to the sub-collector.
No, how can I do that without notice?
Authorize.
Notice.
Notice. Please.
Because the private party is the
Yes, right, but
Mr. G, PG appears for official OPs, emergent notice to other OPs. OP 5.
right.
OP 5. Okay.
IA is there, my lord. Just
An application supported by affidavit in IA number so and so is moved, seeking reprieve against the impugned order dated 29/5/2025 at Annexure 4. First,
learned counsel for the petitioner draws attention of the court to the record to show that he was not giving any reasonable opportunity to represent before the OP number 3, and thus there is violation of principles of natural justice. First of all, he adds that the principles of natural justice are sacrosanct, and their violation would give a cohate cause of action, CHOATE cause of action. First of all, there is force in this submission. Next paragraph. In the above circumstances, the impugned order is stayed till next date of hearing.
Item 7.
Petitioner is a retired block grant employee, has paid for pensionary benefits as per decision of Hemant Kumar Chhatray. Similar cases has been posted to the date.
Issue emergent notice. AGA, Mr. G accepts notice for the OPs. All OPs.
Yes.
No private party.
No.
All right. Call this matter along with WP number.
Similar cases has posted the date.
Do you have WP number?
Similar cases has been posted.
No. Do you have a similar case number?
Yes, Hemant.
You don't have. No. Call in the second week of October. Yes.
Item 8.
Same man.
Similar
to Sanu.
Same order. Instead of second week, make it third week of October. Okay.
Item 9.
May I please, Malak? Malak, yes, the second round of this matter, Malak. Initially, the present petition taken the shelter of the Hon'Ble Court in terms of direction in Hon'Ble Court to consider representation of the parent petitioner. The present parent petition is having a institution's Malak. It's having its own name and fame at Sundargarh Malak. The opposite party number 3, which is a false and fabricated institution who is spreading false informations in the digital media matter, for which the different type of creating different type of allegations and fabricated allegations, as there is different type of allegations and fabricated allegations by the OP number 3 on the social media matter, that this institution is a false institution, they are not giving proper food to the students and all this type of things. Matter.
You file defamation suit.
The director is there, as the Education Act, Odisha Education says,
what he can do?
There should not be unhealthy competitions, This is unhealthy competitions, and this is the rejections order of the director,
What is that rejection? You have not made it part of the petition.
No, because recently, yesterday we have received this copy, The examination of that allegation of the petitioner does not come under the jurisdiction of the Director of Higher Secondary Education, Odisha, Bhubaneswar, as the matter relates to cyber crime related information.
Yeah, it's correct. Even I am of that view. You file civil suit. To restrain him from defamation is not only for damages. You will have LC, Goel on injunctions.
We said that the institution is a false institution.
We do not know.
We have given the information.
Correct. We should be.
When the
before the civil court.
When the notice,
a criminal case.
Yes, when the notice was issued by the director to the concerned institutions, they have by creating a resolution, they have changed all the directors.
Yeah.
And even I have also given them and met party.
Who are you?
I'm one of the director of the organizations.
So it is only the internal rivalry. You file a suit, appropriate suit, or criminal case. That alternate remedy you have. How can we decide all these things here?
Because it's coming under the Odisha Education Act, and it's violating.
Which section?
There is I will provide everything. Even date may be given.
No date will be given.
Short date may be given. I'll
take book. We'll give book to you. Yes, give.
Odisha Education is not manual. There is Act There is
Education
Act. So
Act 1969.
Short adjournment mallet. One day maybe I will provide all the documents. To convince mallards.
First, you have prepared the petition and you want time.
I'm sorry, mallet, because that the Act says mallet, there should not be unhealthy competitions between the institutions mallet, and the director has to look into it mallet.
Call after vacation. The request of counsel for the petitioner who intends to come with more preparation, since at this stage court is not convinced of his submission.
Item 10.
Well, opposed.
Please, Your Lordships. But here the petitioner challenges the order of rejection made by the District Education Officer Khurda, my lord, wherein the claim of the petitioner for salary for the period from 1994 to 1999 has been rejected on the ground that during that period the petitioner didn't possess the training qualification.
You did not have training qualification.
That is their ground, my lord. But that is not required for that period. Your lordship may kindly come to, and that is also contrary to their order of approval. Your lordship may kindly come to their order of approval.
Which rule says that is the requisite qualification?
Then we will file counter in this case.
Issue emergent. Mr. Behra, learned AG accepts notice for OPs. Next.
My lord, I may be pardoned, my lord. I have made a mistake. In the certificate portion, I have inadvertently missed to mention the previous read petition number. I may be permitted to correct it.
Petitioner on oral request is permitted to effect a small and marginal amendment rectification in the petition at page number?
At page number 2.
Page number 2.
In the certificate portion.
Okay, thanks. Yeah.
Item 11.
Item 11. Your Lordship, the petitioner who was working as a guardian in a non-government aided college has challenged the order 36/2025, wherein the opposite party, the principal, has withdrawn the granting benefits extended to the petitioner and has relieved the petitioner from discharging his duties. Though your Lordship may kindly see page 37, though the granting has been withdrawn as per section 7D of the Orissa Education Act, and 7D provides a provision of appeal, but 7D only relates to the institutions, Your Lordship.
You have no appeal?
No, because the withdrawal of granting the prescribed authority may withdraw the granting of a private educational institution, and the appeal provision is the managing committee or the governing body, as the case may be, aggrieved by an order of the prescribed authority, withdrawing the granting may in such manner and within such period not exceeding 60 days as may be prescribed, refer an appeal before the state government, whose decision thereon shall be final. Only the managing committee or the governing body can prefer the appeal.
Not employee?
No, because Your Lordship may kindly see page 37, referring 7.
This provision is interpreted by the court. How other judges of this court have interpreted?
No, this provision is only applicable to the managing committee and the governing bodies.
Mr. Swain, any judgment on that? I read in Karnataka, it's almost similar provision, but we say employee is entitled to do that.
Yes, one judgment is there.
You go before the government. Now there is they are saying there is such a judgment. Right. But if I will direct them to dispose of the appeal as early as possible.
Provided they have followed the procedure under section 70.
That's what.
And 70.
That contention he can take up, na?
Only managing committee can file appeal.
Yes, sir.
That 70 is not applicable to employee.
Yes, Your Lordship. That is my contention.
Applicable to the institution, not an employee. It is so they are using 70 to employee. That is not permissible.
Okay.
That is a preferred rate application.
When you take notice, let us see. Bring that judgment also.
My lord,
so that once for all, issue emergent notice. The DC is requested also. Next.
Item 12.
Any private party?
Only the previous, OP number 3, principal.
Yeah, principal. Principal is also now, it's a aided institution, government, na?
No, but the principal.
OP, college principal notice. Okay.
Governing body has made party.
Governing body.
Yes.
Now government only.
No,
governing body is a private body. It's emergent. You are right. Yes. But one judgment I read where they say even employee can make appeal, even though section is worded that way. Therefore, I told you. Anyway, let us. Next.
Item 12.
My lord, this is a claim of RECP, my lord, and identical cases already payment has been made as per NSR 2, my lord, and NSR 3, 4, 5, 6 identical case office order also passed and payment also made, my lord, and representation is pending, my lord, as per NSR 8, my lord.
Call along with WP number.
The WPC number 23722 by 2025.
You have to say it slowly. You are running PT Usha.
Identical case, my lord, as per NSR 4, 5, 6, my lord.
Just look into that. Yes.
Item 13.
Item 13, my lord, relating to pension matter, we will see past in similar cases 2001725 and list to 3 chapter, my lord.
These similar matters are admitted.
My lord,
Issue emergent notice.
all are government person.
AGA appears for notice.
1 to 3, my lord.
1 to 3. Call along with WP number. Yes.
Item 14.
Pass over on the
No.
That is against the final order. In any case, the lordship may issue notice will file counter.
Issue emergent notice. Learned AGA Mr. Lenka is requested to accept notice for notice. Any private party? No.
No.
All are submitted. Next.
Item
Yeah.
15.
That is, my lord. My lord, opposite party number 2 is a company which has got the lease to extract bauxite from a mountain nearby.
OP number 2.
And they have the headquarter, OP number 3, my lord. They have their headquarter at OP number 4.
OP number 3 and 4 are same.
My lord. They have the headquarter. They have got the lease to extract bauxite from the nearby mountain. Now they are using my land as a transit, your lordship. I'm a SC/ST person, poor man. I don't have much resources to live on. So they are using my land. I sought a notice that why are you using my land without any permission? They threatened me. So I preferred an application before the district magistrate to look into the matter. That is the only.
Annexure 3 is pending.
My lord.
Let collector notice.
Now what district magistrate will do? You have to file a suit for injunction.
But district magistrate under this Prevention of Atrocities and to SC/ST Act
Show that.
is empowered under section 17.
See. Read.
My lord. Section 17.
Yes.
Preventive action to be taken by law and order machinery. A district magistrate or a subdivisional magistrate or any other executive magistrate or any police officer not below the rank of a deputy superintendent of police may, on receiving information and after such inquiry, as he may think necessary, has reason to believe that a person or a group of persons not belonging to scheduled caste or scheduled tribes residing in or frequenting in any place within the local limits of his jurisdiction is likely to commit an offense or has threatened to commit any offense under this act is of the opinion that there is sufficient ground for proceeding, declare such an area to be an area prone to atrocities and take necessary action for keeping the peace and good behaviors and maintenance of public order and tranquility, and may take preventive action.
What is that? Where is the injunctive power?
Preventive action.
What preventive action? For the offense?
Just to prevent them from using my land.
They are not substitute for the civil court. You have to go to civil court. But petitioner is complaining before the writ court that his land is being utilized by the contractors who happen to be OP numbers
3 and 4.
3 and 4. First off, learned counsel for the petitioner submits that his client belongs to the scheduled caste and therefore he is entitled to be protected. So also his property be guarded from being misused by private parties who does not belong to SC or ST. First off, in support of this contention, counsel for the petitioner cites the provisions of section 17 of the Prevention of Atrocities, etc. Act 1995. First off, learned AGA, although initially submitted that his application is pending before the deputy commissioner, the district collector, magistrate, I do not subscribe to the view that the same needs to be considered by the said authority in as much as power to grant injunctive decrees or orders is essential attribute of a civil court. First off, section 17 of the act reads as under. Next paragraph. There is absolutely no warrant for the interference of authorities for granting relief of the kind to the petitioners, to whom the civil courts are wide open for gaining access to justice. First of all, in the above circumstances, petition being thoroughly misconceived is liable to be rejected, and accordingly it is. However, liberty is reserved to the petitioner to have recourse elsewhere in accordance with law. In that connection, all contentions are kept open. How? For everything, saying that I am SC, therefore I should be. Where is the power?
Only under section preventive action from
preventive action for offence.
My lord, that's what they are threatening.
That is not on the ground. It should be on the ground that because you belong to that particular community, and on the ground that they do not belong to your community.
Yes.
How all this should be adjudged?
My lord, they are using and under section 3. There is a provision that they shouldn't be using my land.
Next.
Item 16.
16 may I please, my lord. Yeah. My lord, the petitioner is an institution, submitted an application for opening the institution, my lord. The application was kept pending, no decision was taken, so the petitioner...
Can you be a little louder?
Yes, my lord, the petitioner is an institution, submitted an application for opening the educational courses, my lord. When no decision was taken on the application, the institution preferred an appeal, and the appeal was disposed of under Annexure 4, my lord, wherein it was directed the opposite party number 3 to conduct high power committee meeting and to adjudicate all the applications within a period of 3 months. 6 months have passed and no decision has been taken on till date, my lord.
Let the FPC high power committee may take a decision, dispose of with a action.
The short grievance of the petitioner is reflected in the prayer column of the petition. First of all, learned counsel for the petitioner submits that if directions dated 30/12/2024 at Annexure 4 are carried out or directed to be carried out, his client will be satisfied. First time. Learned counsel, the AGA, Mr. Lenka, submits that he would instruct the OP number 3 to look into the grievance of the petitioner as has been aired in the subject petition in accordance with law and in a time-bound way if all contentions are kept open. First off, this is appreciable. Next paragraph. In the above circumstances, petition is disposed of. 6 weeks for taking the decision in the matter. Yes, all contentions are kept open. If solicited, etc. Okay.
17, petitioner is paying for pensionary benefit, my lord, similar to item 13.
It is similar to
item number 13, my lord.
Issue emergent. That is, you have sought for, you have made a representation.
Yeah.
If that is considered, it's over.
Yes.
Petitioner's representation dated 8/7/2025 at Annexure 6 reads as under. Next paragraph. Learned counsel for the petitioner submits that non-consideration of representations wherein his client has sought for certain pensionary benefits in terms of a coordinate bench decision of this court in Chandra Parida.
Sarat Chandra Parida.
Scottish.
Sarat Chandra Parida.
Sharat Chandra Parida versus State of Odisha. Reported in what is this one?
Volume 120.
In the representation, it is there. Just
2015 CLT. My prayer.
What you have written? Read the sentence, Doctor.
Upheld by the Honorable Apex Court.
It's upheld by the Apex Court. Yeah.
Dismissed on delay ground.
So,
Your Lordship, that was on delay ground, the Apex Court has dismissed. And similar matter is pending before the division bench, that is HK Chotra.
Okay. Anyway, just you look into that grievance and tell him that or no.
Benefit already extended.
First. Next paragraph. Learned counsel appearing for the petitioner, the AGA. Learned AGA appearing for the OPs opposes the petition contending that Sarat Chandra Parida is now put in challenge before the division bench.
No, my lord.
Submits that although Sarat Chandra Parida was carried to apex court, the challenge before the apex court was negative on the ground of delay, and that other similar matters are being examined by the division bench of this court.
Hemant Kumar Chotra.
That is Hemant Kumar Chotra. Right, okay. Do you know the pronunciation and other things? Just right. Just give in writing.
My prayer I have quoted.
Fine. So, and therefore, petitioner should not have hastened to the court during its pendency. Having so contended, he fairly agrees to instruct his client, namely OP number. Which OP to consider?
OP number 1, man.
State?
Man.
Director or state?
No, director, but I have given representation to OP 1.
Numbers 1 and 2 to consider or cause to be considered the subject representation in accordance with law and in a time-bound manner. This is appreciable. Next paragraph. In the above circumstances, petition is disposed of, prescribing a period of 8 weeks for consideration and to inform result of consideration to the petitioner. Open to solicit information and document. Yes.
Okay. Item 18.
Thank you. I will show you.
Matter relating to appointment under rehabilitation assistance scheme. Petitioner husband died in 4/6/2021.
4/6/21.
Applied 27/11/2021. 27/11/21.
In time.
Yes, ma'am. But now.
Who are you?
Ma'am, the wife of the petitioner.
Widow of the
widow. Yes.
He died on 4/6/21.
Yes, ma'am. Earlier direction was given with the direction to consider and dispose the representations.
Now it is rejected.
Rejected.
On what ground?
Ground of the petitioner has not applied in due time with the proper procedure.
No, 4/6/21, he died on 27/11/21.
He says that is his case is that he has applied on 9 September 21, but as per the order under Annexure 7, that he has not applied in proper format.
Is there any format for that?
Yes.
Is it that mandatory?
Yes.
Courts have held it's mandatory.
The law, the rule says.
No, rules have been interpreted by the apex court at least in half a dozen judgments.
All these
applications for compassionate appointment. And the format should not be insisted upon.
No, he has to furnish certain data.
Necessary data he has to furnish.
So we'll file counter in this case.
Issue emergent notice. AGA Mr. Lenka accepts notice for the first up. Since matter lies in a narrow compass, call the same in the last week of October.
Yes.
In the meanwhile, the OPs may file their counter. Okay.
Item 19.
Item 19. All these matters are, your lordship, kept to October. That is RSP Ashok Kumar.
Subsequently, partition this AGA for OPs call this matter. Along with WP number?
24841.
24841 of 25.
20.
Okay.
No, this is the case. 24841.
No, which case? Other case. No, not this. You just make a put up, sir. Sir, must you have to make note of the similar. They may not see. You should note down. Do you have any number? 9. In the last week of October. Okay.
Item 20.
20 Milord, covered by my Lord's order, Milord, Loknath Behra, Milord.
Loknath Behra. Have you brought the judgment? Have you brought your judgment?
Yeah, my Lord's order.
They changed the dates and etc.
Not change, Lord.
But no, you have to change and ask someone. Your friend is sitting here.
Yes, Milord.
Bring that.
Only date is to
Date is to be changed. Just. Yes. Item 22. That is
21.
21 is disposed of.
withdraw.
Loknath Behera.
Withdraw.
20 disposed of. Yes, 21.
Withdraw.
This was withdrawn.
Concerna jo uthal.
Item 22. Yes, 22. Go to prayer.
Here in respect of that transfer of the plot, representation is under Annexer 2, my lord. At page 20.
Who should take decision?
The Special Planning Authority. Special Planning Authority, my lord.
Any panel council are there for them?
No, my lord, this is a government.
Government.
But
You take, you tell them to take a decision on this, provided it is pending.
No, because possibly they have got, because the acknowledgement received at page 20 at the penultimate para, my lord.
Yes.
That has been Xerox.
That's also attached.
Exactly. So no one is there.
Petitioner has made a representation dated 8/8/2025 to the Special Planning Authority, Bolangir, who happens to be OP number?
OP number 3, my lord.
OP number 3.
No, sorry, OP number 2, my lord.
OP number 2. Go to representations. OP number 2.
OP number 2.
Seeking permission, seeking transfer of the khata in favor of his daughter.
Her daughter.
Father? No. Daughter namely Prajna Pranita Mishra. Father?
Yeah. The
Daughter,
applicant is a lady, my lord. Her daughter.
But petitioner?
Ashiel. My lord, the petitioner is now.
8/8/2025. That annexer 2, which reads as custom. Learned counsel for the petitioner submits that a short prayer has been made, and if a direction is issued for consideration of the subject representation, comma, his client would be satisfied. Next paragraph. Learned AGA Mr. Mohanty, in his usual fairness, agrees to instruct OP number 2 to take a call on the subject representation if all contentions are kept open. First off, this is appreciable. Next paragraph. In the above circumstances, patient is disposed of, so he is open to solicit information. No course.
Item 23.
Yeah.
Challenging the order of rejection, my lord, in the annex of 15 on the
similar matter.
Yes, they requested a matter of
notice. Mr. Mohanty accepts notice for the OPs. All OPs, my lord. All along with WP numbers. Yes. Next.
May I please, Mal?
Item 24.
Mal, the present petitioner is a resident of Kesinga under Kalahandi district, my lord. This is a residence. Kindly have a glance, page number 9, annex 2, my lord. This is a map, my lord. This is a map of the locality, my lord.
Illegal construction to be halted.
Yes, my lord. This opposite party number 7, my lord. But very surprisingly, he has taken the permission of the NAC, the executive officer NAC Kesinga, for another plot, which doesn't belongs to him, my lord. That belongs to a scheduled caste person, my lord, who is a different person, who is unable to come to this honorable court, my lord. On his plot, my lord, this person is now constructing his house by obstructing the road and the plot of the present person, my lord. It is clearly, my lord, shown from the annex 2, my lord. Please kindly have a glance, my lord, page number 9. Where it is clearly mentioned, the petitioner's plot is, there is Dhaneshwar Mishra, and that adjacent plot is Oda Keuto. That is plot number 963/1577. And the plot of the opposite party number 7, just on below, my lord, that is Rajanikanta Das. But this person has taken permission on the plot of the Oda Keuto and now is constructing his house, my lord.
No, that plot does not belong to you.
No, my lord.
It belongs to someone else.
No, but he is constituted on my plot also. Because
then it's a case for injunction.
Yes, my lord. But my lord, this is coming under the NAC, my lord, and the permission has been granted by the executive officer NAC, my lord.
Correct.
He has given in a wrong plot, my lord.
Correct.
The plot which doesn't belong to the opposite party number 7, my lord.
No, you are not concerned with that plot at all.
My lord.
If your plot is being encroached,
yes, my lord,
you go to civil court. Civil courts are wide open.
Because my lord, is related to NAC, my lord, so I have come before this honorable court, my lord.
No.
I have taken shelter of this honorable court to immediate, my lord, to...
No, immediately there is an injunction.
But there is some difficulties, my lord, that's why I...
No, that difficulty will have every suit in every...
I will, my lord, because my leg is before my lordship's.
So, brother,
my lord.
these are all, otherwise I will not say.
So the NAC is given a wrong permission on a wrong plot, mal.
Anyway, and it is your side going for it.
And my several representations are there that is pending before the IAC. Even I approached the police, even I approached the NAC, the executive officer, Tahsildar, but nobody is taking interest, man.
You make representation to Vice President of India now. How that's going to help you? There is some method. If you have got a problem in nose, throat, eyes, then ENT expert. Problem with heart specialist. You have to choose.
Yes, ma'am.
You cannot. This is not panacea. Writ jurisdiction is not panacea. It's not rampart for everything.
Because the permission granted by the NAC, my lord. That's why before my lordship's, my lord.
The essential grievance of the petitioner relates to alleged encroachment perpetrated by OP number,
that is OP number 7.
OP number 7. First number. Learned counsel for the petitioner vehemently argues that the jurisdictional authority has given wrongly the construction permission in respect of a plot belonging to some other person, and that OP number 7 is putting up construction on the said plot apart from encroaching petitioner's land. First of all, he also submits that his client has given a representation to OP number,
that is 4, 5, 6.
OP numbers 4, 5, and 6, and that nothing has been done in the matter. First, he submits that there is a duty cast on the OPs to take action in terms of the representation. Next. Yes, what do you say?
Well, 4, 5, 6 is the collector, Tahsildar, and executive officer.
Yes,
if all urgency is there, 144 provision is there also. They can avail.
But the situation is something different, man. Nobody is taking interest, man. There is some political involvement also in this matter.
Mr. AGA Mohanty appears for the petition and submits that in rare cases, ordinarily, the provisions of section 144 of CRPC like thing are invoked. First, having considered, having perused the petition papers and having considered the contentions at the bar, this court declines indulgence in the matter in as much as the fact matrix is not possible to be ascertained as to which plot belongs to whom and who is constructing on which plot and which plot is being encroached by whom. First of all, thus the disputed facts ordinarily the rate court will not be able to decide. First of all, next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to approach the civil court.
Why not my representations should be considered, my lord? My representations are pending. Until that, my lord, a stay may be granted, my lord.
No.
Because it's constructed on my plot, my lord.
You can go for injunction, brother. Well, first, if petitioner approaches the civil court, the learned presiding judge shall give preferential treatment to the cause, regard being had to the urgency pleaded before this court. First off, in that connection, all petitions are kept open.
Item 25.
Yes. May I please, Your Lordship? But the opposite party number 5.
Yes.
By forging my signature, executed an agreement of rent for establishment of a school.
Writ remedy is not a substitute for an injunctive sentence with some that.
But here my grievance is the opposite party number 5, by forging my signature, executed an agreement by the notary, my lord, for rent, for establishment of a school that is under Annexure 3. And on the basis of that agreement, my lord, your lordship may kindly turn to Annexure 8 at page 46. The district education officer granted, my lord, the certificate of recognition under section 18 of the Compulsory Education Act 2009.
Where is that agreement?
But that agreement is under Annexure 3 at page 26.
How this court should decide
Yes, there is a remedial provision. Your lordship may kindly see that. That is, your lordship may kindly see the Compulsory Education Act 2009 first. Section 18. Saying that no school to be established without obtaining certificate of recognition. No school other than a school established, owned or controlled by the appropriate government or the local authority shall after the commencement of this act to be established or function without obtaining a certificate of recognition from such authority by making an application in such form and manner as may be prescribed. Prescribed means prescribed under the rules.
Whether you are state or other person.
Yes, your lordship may kindly see. Well, the remedial measure is, your lordship will get it from the Compulsory Education Rules 2010. My lord, your lordship may kindly see Rule 13 that deals with recognition to the school. Then your lordship may kindly see Rule 14, withdrawal of recognition to schools, 14.1, where the district education officer / inspector, stroke inspector of schools, stroke district inspector of schools, as the case may be, on his own motion or on any representation received from any person, has reason to believe that a school recognized under Rule 13 has violated one or more of the conditions for grant of recognition or has failed to fulfill the standard prescribed in the schedule, he shall act in the following manner. A, issue a notice to the school.
What is that power? Power is posted.
But the power is, but here, my lord, by executing a fake agreement.
To decide it's a fake agreement.
But my humble submission before your lordship.
Is it registered agreement?
No, not registered.
Unregistered agreement.
Unregistered agreement made by the notary. But my submission before your lordship is, I have made a representation to the district education officer who has granted recognition under the Compulsory Education Act and also under the Compulsory Education Rules 2010. And the remedial provision is Rule 14. I have already made an application before.
How he will decide whether this is a forged document? Apex Court said whether document is forged or not, the authority shall not decide. It's only the civil court for cancellation of the document.
But since there is a provision under Rule 14, let the district education officer consider it. But
otherwise, he will say, High Court has directed me, therefore I am comparing signatures, I will come.
No, the person concerned
is a transfer under Section 5 of the Transfer of Property Act. If we direct him to consider your representation, he will be jumping into the uncharted sea of Section 5.
But some of them that aspect. My submission before your lordship is, since he has failed to fulfill the conditions of recognition, and I have made an application before the district education officer. But
what is that failed to? What condition?
The condition of land and building is not there.
No, that whether there is an instrument.
Yes.
Whether instrument is good, bad, valid, etc. Once it is acted upon, it is for you to go to civil court.
But I may approach the civil court, my lord, I don't have any hesitation. My submission before your lordship is one thing your lordship
petitioner has
But may I suggest one
This
thing?
court kindly be seated. Petitioner is hearing his grievance with the following prayer in the texted in the petition. First off, learned counsel for the petitioner vehemently argues that the recognition and permission that have been issued under the statutory provisions in respect of the land are founded on a forged conveyance, and therefore his application for rescinding the same needs to be considered by OP number 3. First, he also draws attention of the court to the provisions of Compulsory Education Act 2009 and the rules promulgated there and there in support of his contention. Next paragraph. Having heard the learned counsel for the petitioner and having perused the petition papers, this court declines indulgence in the matter in as much as whether the instrument or conveyance is forged or fabricated cannot be decided by the authorities constituted under the 2009 Act. First, where a case of the kind is sought to be made out, the writ court cannot undertake a deeper examination of the same, regard being had to the conventional limitations that have been operating since the advent of the Constitution. First, next paragraph. In the above circumstances, petition is rejected in limine with liberty to the petitioner to approach the appropriate forum for adjudication of the list. In that connection, all contentions are kept. Next.
Your Lordship may say that petition is disposed of.
Yeah, petition is disposed of. Okay.
Item 26.
May I please?
Yes.
Petitioner is a retired principal of an institution, my lord. He's not getting his pension. He has been retired since.
You want a suspension to be treated as duty period?
Yes, my lord.
Why?
My lord,
what happened in the DE?
My lord, they have no disciplinary proceeding has been initiated. Only they have suspended me and kept for 8 years without any reason, without any order. After the suspension order, they have lifted in 2008. In 2001, they have suspended me and they have not given me the subsistence allowances for which I approached this court. After interference of this court, they give me the allowances and they lifted the suspension order. After that, after lifting the suspension order, I have resumed in my duty in 2008 and the suspension period has not been regularized, for which I have repeatedly made representation to the authority.
Why, brother?
Let the operating part, the impugned order is at 51.
And next 11 is impugned.
Annexure 11, madam.
Annexure 11. Yeah.
Inviting the reference to the letter number such and such note, I am directed to state that the proposal for sanction of the pensionary benefit in favor of the petitioner, retired lecturer, is not considered due to the following objections. Service verification for the period 16/3/1998 to 5/4/1998.
Make verification.
The authority may law.
Then why can you find fault with her?
Well, for that purpose, this has been returned back.
No, who should do all that? Which officer should verify? Principal has not attested the entries made on so-and-so service book. Why you should have asked him? Why you have not attested the entry?
So it has been sent to the principal, my lord. It has been sent to the principal by the director for compliance of all these shortfalls.
And
this was in January 2020.
This is in 24, my lord.
Then they will sleep over the matter for another decade. How many times the candidate should approach the court? You take notice, I may impose heavy cost on all these OPs unless they do something in the meanwhile. Already
my lord, principal already on by annexure 8.
They have to file objection.
Oh, my lord.
Issue emergent notice. Petition, the learned DGA, Mr. Mohanty accepts notice for
Here, my lord, your OP number.
All OPs. Principal in charge.
My lord, 1 to 6.
1 to 6. Emergent notice to OP number 7.
OP number 7.
First one. On perusal of the petition papers, there appears to be some lapse attributable to the official OPs as well as the principal of the institution. First off, if the same is demonstrated fully at the time of hearing, heavy costs may be levied on the OPs. However, it is open to them to address the grievance of the petitioner and place their views in the form of affidavit on the next date of hearing. First one, call this matter immediately after service. Okay.
Item 27.
Sorry, since it is a second round litigation. Yeah, 20.
Please. Now, may kindly come to Annexure 3 at running page 14.
Annexure 3.
Running page 14.
What is that?
My lord, a departmental proceeding was initiated against the petitioner only on 6/1/2024.
What was the charge?
Well, the charge was charge they have mentioned as irregular in duty, disobedience of order of higher authority, negligence in duty, and violation of government order. These are the charges. And sleeping on duty hour. My lord, you lords may kindly come to, well, after the charge was framed, straight away a punishment order was passed without any inquiry, without appointing even the inquiring officer for the purpose.
Did you deny the charges?
Yes, my lord. That there, you lords may kindly come to the punishment order itself, or on page 18.
Page 18?
Yes, my lord. Whereas a departmental proceeding was against Srimati Jayanti Maharana, so and so, under Rule 15 of the OCS CCA rules, whereas Sri Maharana, assistant teacher, in her written statement framed against her, is received on 1/2/2024. Thereafter, it reads like this. Your written statement was considered by the inquiring officer. No inquiring officer was appointed after the proceeding was initiated. But straight away, they have imposed the punishment.
But there is a video clipping which shows you were sleeping in the classroom.
My lord,
on the chair.
Well, unless that is inquired into, can I
show that prima facie? No, we are in the writ jurisdiction.
My lord,
prima facie, if the teacher sits on the chair. Suppose if the judge just sleeps in the court, what will you do?
My lord, that is
you will make it viral in everything.
My lord, that was the entire issue. My lord, a viral clip was made and a preliminary inquiry was conducted. After the preliminary was conducted, inquiry was conducted, a regular inquiry was initiated.
But see, first charge at the time of inquiry, after mentioned that you were slept on the chair in classroom. 1 second. Like page number 18, I am reading. Perhaps she appears to be Kumbhakarna Kula. See the second one. It is clearly shown in the video clipping. You were sleeping in the classroom in teaching period. Corporal punishment to the students. Personal work, etc. What inquiry you had held, brother?
It appears, my lord, that they have inquired the matter in the appeal order, my lord. Passed by the appellate authority. Lordship kindly have a glance.
No, he says inquiry is not held at all.
Well, that was also the ground before the appellate authority. There was no inquiry. This honorable court directed the appellate authority to consider my appeal from the proper perspective. Instead of doing that, the appellate authority straight away passed that the order confirming it, which is under Annexure 7. I had approached this honorable court earlier against this. This honorable court directed to take all these grounds in the appeal and the appeal to be disposed of. I had taken those grounds, but nothing is there.
And one annual increment is one censure, and one censure is a warning. That comes in the morning and goes in the evening. Censure.
censure, my lord, it's not a question, my lord. Question is, whatever punishment is imposed, that is under a rule. As your lordship is well aware.
Take notice, my lord. Take emergent notice. ASC to accept notice for the OPs.
The miscase is there for. My lord, there is a miscase for stay of the punishment.
When it was issued, impugned order?
My lord, the impugned order was issued.
Punishment was issued on which day?
On 11th July 2024.
24.
And the appellate order is.
Appellate order affirms it.
Yes. That is on 17th.
More than 1.5 years are over now.
My lord,
1 year, 2 months, or 3 months.
Your lords may kindly kindly keep that IA pending so that it can be, because the reaction shall be subject to result ultimately.
Notice on both the main matter and IA. Yeah.
Oh, best. Your lords may fix a short treatment.
Since matter lies in a narrow compass, call this matter in the third week of, immediately after, in the third week of October.
Oh, best.
Item 28.
Lordship, the petitioner wants to withdraw this petition.
Counsel for the petitioner has filed a memo seeking leave of the court to withdraw the petition. Where is memo?
Same are provided.
The memo reads as under next one. In view of the above petition is disposed of as having been withdrawn. Registered to send copy of the order to the OPs by registered by street post. Yes.
Item 29.
After sexual harassment in working place, I had filed an application before the authority, and after obtaining this, the authority has formed a committee by the Annexure 7. That committee is not within the law because there must have a glance at Section 4. The committee.
Who were you? You were the victim.
My lord. Section 4 it says there must be a presiding officer who shall be a woman employed at a senior level at workplace from amongst the employees, provided that in case a senior level woman employee is not available, the presiding officer shall be nominated from other offices or administrative units of the workplace referred to the subsection 1. Provided further that in case the other offices or administrative units of the workplace do not have a senior level workman employee, the presiding officer shall be nominated from any other workplace of the same employer or other departmental organization.
That member was absent in the committee?
No, ma'am. That woman member was not there. They have appointed a data entry operator as the presiding officer. That is.
Take notice. They have acquitted, they have exonerated the person.
No, now he is in the committee. I am challenged that committee before your lordship.
No further proceedings?
No, nothing. Nothing has been done now.
Issue emergent notice. Yes, brother, the next date you tell, you reconstitute the committee and do it. My lord. Call this matter immediately after vacation. ASA accepts notice. Yes.
My lord, IA at there.
An application supported by affidavit in IA number so and so is filed for stalling the committee proceeding on the ground that committee is ill-constituted, and there is violation of the provisions of so and so act. Write down and do that.
My lord.
Act. Personal. Prima facie it appears so. Personal. Next paragraph. In the above circumstances, application having been favored, the committee shall not hold any further proceeding till next date of hearing. Call this matter in the last week of October.
Item 30.
May it please, Your Lord.
Yeah.
Well, it's the Cuttack Development Authority floated a scheme for allotment of plots through lottery. The Lordship may have Annexure 1, page 18, that is the brochure. And at page 20, the eligibility criteria is fixed. The relevant is at page 21, clause 4.7.
4.7.
Page 21.
What it says?
But it says household income
eligibility criteria for applicant G category.
I belong to the F category. Therefore, similarly, household income eligibility criteria for applicants for F category shall be from rupees 1.8 lakhs only to rupees 6 lakhs per annum as per the income eligibility prescribed under the policy for housing for all in urban areas, Odisha.
Now what happened?
At Annexure 5, page 66, on the basis of my income tax returns, I have been declared as ineligible.
What is your declared income? What is your taxable income?
I'm grateful, Your Lordships. If Your Lordship sees page 51, that is my income tax return.
51.
Page 51. My taxable income is 1.48 lakhs, but my aggregate income, which includes agricultural income, is 4.8 lakhs.
Yes, but the question is, under the scheme, which is that famous judgment, Bela Banerjee versus White, it is only for the purpose of taxation.
Yes, ma'am.
Agriculture income is not taxable.
I'm grateful, ma'am.
But for the purpose of fixing the slab under the IT Act,
I'm grateful.
That is also taken note of.
Yes, ma'am.
But if your income is more than the prescribed limit, that is sufficient.
My income is 4.8 lakhs aggregate income.
Yeah.
Therefore, I am eligible.
It is below?
They say it is below 1.48, but that is taxable income. My rejection is at page, if Your Lordship sees my rejection, it starts at Annexure 5, page 66.
66. Item number?
Annexure 5. Item 30 minutes.
Item number?
Item serial number 32.
32. Serial number 32.
They say low ITR for year 22-23, rupees 1.48980, which is low annual income as per brochure condition of F category. Now, it's from my IT returns, which are available at page 51. My taxable income is 1.48, no doubt, but my aggregate income is 4.8 lakhs.
Take notice. Issue emergent notice.
Now, the rejection list was published on the same day as the allotments were made.
Let us see. ASC for number 1, madam, and emergent notice 2B2. Post immediately after service.
There is an IA.
No, nothing can become. And item 31. Yeah, I'll come back within 1 or 2 minutes.
Yes. It's a claim for division of pension.
Revision of pension. On what ground?
On ground, manner, this has been held by this Honorable Court in 2022 that having training qualification, I'm entitled to a higher scale. In the meantime, I've retired, madam. And I have given the
entitled to scale of 1,080 to 1,800 yes, from 1,589.
Yes, madam.
When you got value addition?
Value addition was given, madam, in 2010.
This scale is to be given on account of what?
On account of higher scale of pay. On account of having higher qualification.
When you got training qualification?
I have got training qualification, my lord. That is, I have given that copy also. Annexure 2, my lord, page 15. It was in 1998. But the issue was settled, my lord, in 2022 only. That judgment I have given Annexure 6.
Any decision is taken by them?
No, so far not taken.
Which is that annexure representation?
Well, I have not filed representation. Copy of representation he is not having, my lord, because he is an old man.
But the old man has come written the petition.
No, I can, if you not say problem, I can file a representation along with that copies.
Okay. Wait down. The petition prayer number 1 is as at next one. Learned counsel for the petitioner submits that on account of his clients making his client's making of value addition, namely, which is that
that is CT qualification, madam.
CT qualification, acquiring CT qualification, comma, he was entitled to the pay scale of rupees 1080-1800 with effect from 1/5/1989, and that having not been taken into account, comma, his pension has been fixed under the ORSP rules 1989.
In the pay scale 975 to 1660.
In the lesser pay scale, and therefore the mistake has to be rectified by the office first. He also points out that the coordinate bench decision in WPC number 12831 of 2017 decided on 18 by the coordinate bench on 18/7
by division bench.
By the division bench. Yes, the division bench on 18/7.
That is around 18/7/2019.
2019 supports case of the petition, and therefore this court should come to the aid of his client first. Next paragraph. Learned ASC on request appearing for the OPs opposes the petition, contending that ordinarily for issuance of writ of mandamus, comma, a demand and rejection or a sine qua non, and therefore petition should not be entertained in the absence of such a demand. First, at this stage, petitioner submits that if liberty is given, he would make an appropriate and comprehensive representation to the jurisdictional OPs, and his client would be satisfied if a direction is given to consider the same after it is made. First, this is fair and reasonable. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to make the representation within 2 weeks. And if one is made accordingly, comma, the jurisdictional OP shall take call thereon within 8 weeks next following, in accordance with law. First, in that direction, all contentions are kept open. It is open to jurisdictional OPs to solicit. Next.
Item 32.
Yeah.
Well, the petitioner has been ostracized by the villagers. Villagers means by the instance of the opposition 514.
Petitioner
ostracized. There he has not been allowed to use the public duel.
Excommunicated.
Yes. Use the public duel, public deity, public tank.
On what ground?
Well, on ground they wanted to take a road, see, opposition 5 to 14, wanted to take a road on the land of the petitioner on plot number 113, my lord. He did not allow it.
Did you give any representation to the officers?
No, collector, my lord. Collector referred it to the Tahsildar. No action has been made on 4/8/2025 and 2/6/2025. I have given. The lordship kindly come to page 13, my lord. Receiving officer is there, my lord. They are not allowed me to cultivate that my land also in the village.
Does it belong to scheduled caste, scheduled tribe, etc.?
No, my lord. I am not a scheduled caste.
Then you have to file a suit.
No, ostracized my lord, completely. That is my life and liberty. Everything has been confined by the opposition 5 to 14, my lord.
5 to 14.
Yes.
You should file suit against them.
Shoot, my lord, then shoot, my lord. It is Article 21 is violated. Therefore, your lordship may direct the collector.
Where is Article 21?
Life and liberty, my lord.
Well, it's not against, it's against the state. State has not done, you prevented you from going to the well, going to the school, going to the hotel.
State, I approach the district magistrate. District magistrate is to take action, my lord. Because I have to freely live in my village, my lord. It calls my district administration to take steps, my lord.
No, that you live, you should be permitted to go to well, go to walk, go for
I cultivate my land, my lord. Protection should be given by the state, my lord.
If you want protection,
I will be helpless, my lord.
That is the reason you should go to the help.
So nothing will happen, my lord. Only that you will also direct the collector to take, then let them take instruction what happened, my lord.
Yes, ma'am. Yes, ma'am. I will take it. At least well and public places, well, school, hospital. To these three, nobody can be prevented.
To cultivate my own land bounds.
No, that relief will not grant you. That amounts to issuing the writ court issuing the injunctive decree, which in Swain's matters we did not.
My lord, they should allow me to my lord freely use that road. Dual event, my lord, that is situated in the saline area near the coast of the Bay of Bengal, my lord. The water is completely saline. Is to use the drinking water from tube. They are not allowing me to take the drinking water.
Since how long you have not been allowed?
Well, that is from the month of June, my lord.
How is that you are living without water?
Well, I am bringing from other villages.
Which village you are bringing from? Where have you stated?
That I have, my lord, I have not stated that fact.
Then if you say something out of the...
No, I have taken instructions, my lord, where...
That instruction is irrelevant. That should be reflected in the pleadings. You might have given so many instructions to you.
Yes, my lord. That I have not stated, so, but they are not allowing, my lord. I have to...
Just look into that. Yes, he is requested to accept notice for the
OP number 1 to 4, my lord.
OP numbers 1 to 4.
Others are private, my lord. 5 to
emergent notice to others. Yes.
Item 33.
Post immediately after service.
Well, item 33, my lord, may be permitted to withdraw because they have complied yesterday.
Learned counsel for the petitioner has filed a memo. Give memo. Seeking leave to withdraw the petition on the ground that there is a compliance. First off, the compliance letter filed by the ASC is placed on record. Okay. In the above circumstances, petition is dropped. Contempt is dropped. Contempt proceeding is dropped. Next.
Item 34.
May I please?
Yes.
Lord, I am conscious of the fact that in case of revaluation, your lordship may not interfere. But there are two decisions of the Honorable Apex Court. That is 2018 2 SCC page 357. Ranvijay Singh versus State of UP. And another decision is 2018 7 SCC page 254.
UP Public Service Commission.
UP Public Service Commission. My lord, where injustice is apparent, my lord, in that case the court can interfere. Here your lordship may kindly see, this is also a demonstrative case.
But 2018 7 SCC related to recruitment process.
Yes, recruitment process. But so far as the ratio is concerned, the ratio is said, my lord, if, my lord, I would convince your lordships that on the face of the answer given by the petitioner,
which subject?
In English, since my lord has got, my lord's English is very enriched.
No.
So therefore, my lord,
except reading Wren and Martin.
Admittedly, my lord's English is very enriched.
Yes.
My lord, your lordship may kindly see, only in English paper, only in relating to one question, answer annexure 5 at page 30. Your lordship may kindly see the question first. Of course, it is of descriptive type. Question number 2. Prepare a report in about 200 words, page 31, on the activities of the National Service Scheme unit of your institution in a village
camp conducted on the theme remove illiteracy from the village for submission to the principal. Then alternative question. Well, I have answered this alternative question.
A village has
been totally burnt by a fire accident. As a reporter of a popular daily newspaper, prepare a report in about 200 words, giving estimate of loss of human life, cattle and property to provide relief to the affected villagers. Now, Your Lordship, kindly see the answer sheet which I have obtained under them by depositing requisite fees. Your Lordship, kindly come to page 24. The alternative answer, title. Well, as per the scheme of evaluation, there is step marking. Title, the village was burnt. The Times of India, Cuttack. Chhokana, Kendrapada. Chhokana is the name of the village, Kendrapada. 19th February 2024 in the village, Chhokana was burnt in last night by a fire accident. There are 2,000 people live in that village. 200 houses were burnt and destroyed. 10 cattle were burnt. 20 people lost their life. 50 and more people were seriously injured. They were treated in SCB Medical College, Cuttack. The collector of Kendrapada visited the places and sought to see that the villagers which were alive, that is, who were alive, they have not feet to eat, not clothes to wear, and not house to live. The collector was announced that is a mistake for the villager that to provide cooked food in relief for 10 days. The Honorable Chief Minister visited the hospital and see the victims. He announced that free medical treatment for the victim. Honorable CM Sir announced that for 1 lakh for the dead, then rupees 50,000, 1,50,000 for the villagers which has no house. There are some grammatical mistakes, but now
mistakes galore.
Yes. But since as per the scheme of evaluation, since there is a step marking, for this question, total marks is 10. Out of 10, he has got 0.
0 appears to be too low.
Yes. Your Lordship, I kindly come to page 16.
In English, Krishi's writing.
Yes.
At least he should know where one should use. See, he has used who, which instead of who.
Yes. There are mistakes.
And series,
grammatical mistakes. Yes.
Honorable Chief Minister, sirs.
Yes.
Kindly see that.
Yes.
SIRE.
Yes.
Sire.
Spelling mistake is also there.
Not only spelling.
Yes.
No, complete. The word will be different. Sire, grandsire.
I am conscious of that. Grammatically, mistakes are there.
In English, what is there except grammar?
That is true. But so far as awarding of 0 mark.
0 appears to be on the lower side. But suppose if 0 appears to be on the lower side, if it was even the sheet was kept blank for keeping blank.
Yes.
There are some old English judgments.
Yes.
He had kept the sheet blank. They said 0. They said for blank also you should award. Very old judgment.
Yes.
School law.
And here you also kindly see his performance in other subjects. That is under Annexure 2 at page 11. He has
Mr. Swain, language is very important.
Language is very important. But I am conscious of that.
In fact, Harold Lesky, the great professor in Manchester University. In fact, there is there were 2-volume letter correspondence between Oliver Wendell Holmes, the great Holmes, and Harold Lesky.
Yes.
He says, the fall of linguistic standards herald the fall of civilization.
Yes.
If language is bad, then what is said is not what is meant.
Yes.
Then what is said is not what is meant, then everything will be difficult. One case,
Yes, by language.
weird, I am just telling you.
Yes.
It was the English. The concerned officer sent a letter, medical officer, saying that his 2 kidneys, one of the kidneys should be removed. And the person who translated it,
Yes.
he did not use the word kidney. He used something else, which I cannot remember. And 4 increments were withholding of 4 increments with cumulative effect. That was ordered. And he challenged it before the High Court. The very judge was very witty judge. He said, you should undergo that operation. Anyway, take notice, what they will say.
Yes.
Issue emergent notice. Who appears?
Well, here council of higher secondary education. Mr. Notice may be issued.
Yeah. Emergent notice 2. 2 and 3.
2 and 3.
Yes, yes. 1, 2.
No, 1, 2, all emergent notice.
All emergent.
Post immediately after service, since matter lies in a narrow compass. Yes.
Item 35.
May I please? Last week matter was there, Lordship wanted to see the rule where manner by which manner 2 gradation lists can be prepared. One is based on graduation and one is based on BEd graduation. IA graduation, BEd graduation. Your Lordship wanted to see that rule because I have qualified manner graduation, but my name doesn't appear in that list.
Okay, this is post notice or notice to be issued?
No, very first time now. Notice to issue.
Let notice go.
Then one point you Lordship may see the prayer. There is multiplicity of prayer having no nexus with each other.
That any one prayer you could have granted.
No, he has also challenged the transfer order. Second prayer.
Well, I may not, if your Lordship will permit me the first application, if my name would be there, Madam, I would have been placed in that place. My junior Madam, because of having that gradation list name.
Correction of gradation list for the purpose of promotion.
That there. That gradation list, if you also look at annexure 4.
You give up the other prayers. Otherwise, how? There is one provision in CPC, which misjoinder of prayers, misjoinder of parties, misjoinder of causes of action, misjoinder of parties.
My prayer is, it's a consequential prayer. What has happened, my lord, because of my not being placed in the gradation list, my junior, my lord, his name being there, he is placed above me in the same school. That's why, my lord, I have said.
To take notice and Mr. Lenka is requested to accept notice for the OPs. All OPs? Private OP is there? Emergency?
Yes, only one is there.
5. Post immediately after service. Yes.
Item 36.
The IMLR notice is also in line.
Yes. What's up?
My lord, the limited prayer, my lord, the petitioners were appointed, being selected as a professional, as a young professional to, my lord, under a project, my lord, of opposite parties. And the project, there's on completion of 3 years, the project was terminated. But their arrear salary, my lord, at the rate of 2 on the basis of some period has not been sanctioned. They have made representation, my lord, and that is authority has also recommended. By the Annexure 6 series, they have made representation, and Annexure 7, 8, 9 are also recommendation. Only limited, they are now terminated from the project on completion since 2023. But the areas are still lying. Your Lordship may direct to disposing that.
Yes, so you can consider this because there are recommendations. University.
State is not a party.
Oh.
I have contacted yesterday the council. Because if you Lord dispose the representation, we are not required to appear.
He said like that. You bring Patnaik. Who is the council? Who is the council?
Only in case notice we will. If your case will.
No, I will direct them to consider the representation. You go and bring the council. Panel counsel, who is the panel counsel? You write down which panel. You have to write down which panel counsel appears for which body. You should have a list of all those people, so that we can immediately make the order.
The lordship may dispose of so that their appearance not.
No, you can't say that. Tomorrow they will file appeal saying that the direction is given without hearing us. Then I cannot go and defend that. Issue emergent notice.
Your lordship may post it after lunch. I will
pass over.
Pass over.
Yes, next.
Item 37. Please, Yours.
Yeah.
Last occasion, your lordship has directed the respondent 3 and 4 to file a exact copy of the counter and a report of the CID and CB. The respondent 3 has supplied the copy, but the CID report still silent remained, your lordship.
Lordship, kindly see the last word.
Yes, sir.
2 lines.
Yes.
2 lines.
On his request, the matter was posted to me. Matter is posted.
Earlier, we have filed the copy of the CIDCB inquiry report by lot, but as per my learned friends, we have already prepared only to attested copy. The inquiry officer has
you all copies.
No, that has not been completed. Only 2 days requirement. Only my
kindly acknowledge my predicament. This is listed as per my prayer. Time and again I mentioned the matter. I am not getting salary since 2018. You also visualize my predicament. For that sake, you also listed the matter for orders. And
Monday will Saturday.
Yes, only my prayer.
Yes, filed the report by lot, but as per my lot, they have filed
it. Seal on that.
Yes, ma'am.
They are justified.
Yes, sir.
Saturday at the request.
Current lordship may call this matter on Monday. Saturday I have some difficulty.
All right. In the orders, in the same.
In the same. Next.
Item 38.
In this case, against the order of FO, the state has filed the review petition, which is covered by your lordship.
Lordship's judgment was that
not maintainable.
The view is not maintainable.
Not maintainable.
You beg for me.
Yes, order. Well, there is also delay, 199 days.
Will condone delay. Review petition is filed after booking a delay of 199 days. First, a separate application supported by an affidavit is moved, seeking its condonation. First, in all fairness, learned counsel appearing for the OP submits that he has no much objection for condoning that. First, even otherwise, plausible explanation is offered for the delay. First, in view of that, application is favored and delayed. Okay. Thereafter, the next is for.
Article 39.
39, in this case, the copy has not been served upon me.
You copy.
Man, I have filed a miscase for recalling of order.
Recalling the order.
Recalling order.
And he is also not taken any step for limitation.
Dismissed.
You have to file application for condonation of delay.
Condonation of delay, that has not been done.
Give copy of this one along with file application also. All right, call after vacation at the request of. Yeah.
Item 40.
Yes.
Respondent number 1, government had filed out.
Yes, Mr. G, are you ready in the paper?
Item 40. Lordship may call this matter
after weekend.
There is also delay there.
After holidays, so that.
How many days delay?
It has not been written in the petition. But might be around 1 month or more delay.
Any application is filed?
Yes.
We'll condone the delay.
Yes.
We'll hear it on merits.
Discuss number 468 of 2018. Discuss number 468 of 2018.
Same. Delay. Yes. Call of application.
Item 41.
Just looking for
This is that the appeals against the order passed by the London State Education Tribunal in the same institution, in the same college. Another matter, you will also be pleased to issue notice.
Call a lot. This notice is not ordered in this matter.
No, man. For the first time it is come.
First time. Okay. Issue notice. Who accepts notice for whom?
1 and 2, the government.
1 and 2.
Notice is to go to the OP number 3.
OP number 3. Urgent notice. Yeah.
Item 42.
Yes. Your Lordship may kindly
post notice matter.
Yes. Well, your Lordship heard this matter.
Yes.
Day before yesterday. And your Lordship directed the State Council to produce the appearance of students in MIL Urdu.
Yes. I am with the
class 10.
I am with the instruction today.
Yes. Alert.
I am filing it
In
without
order to impress your Lordship's memory.
No, you wanted that your category to be so that it is 7,000
Yes,
something like that.
Resource teacher. 2 things I want to point out. Your Lordship may kindly see, because my learned friend's contention was that previously there was no post of Urdu teacher, as per the yardstick dated 8781. But that is not correct, because as per the provisions of the Orissa Education Code, that is 533. Your Lordship may kindly see that is not available in that book.
What is it?
Because your Lordship may kindly see 533 of the Orissa Education Code. Prior to enactment of the Orissa Education Act, Orissa Education Code was governing the field. Since it is a bundle of executive instructions and it has got no statutory force, therefore Education Act was enacted. The statement and object of the Orissa Education Act, if your Lordships will look at, your Lordship may kindly see
we don't have in the
Article 533. 533 of the Orissa Education Code.
23.
Yes.
You give one full Xerox copy of this book.
Yes.
2 copies you can give.
Yes.
So that,
Your Lordship may kindly see 533. Urdu teachers in high schools.
Some
arrangement similar to that required for middle schools.
No, you take your book and give me the Xerox of that. Give this. It's your book, na?
Yes.
Last 533. Okay. Some arrangement similar to the required to that required for middle schools is necessary for the upper classes of high schools in which modern Indian language medium is
introduced in high schools in which Mohammedan peoples are reading. One of the graduate teachers would also be able to teach Urdu translation. Similar provision was there for middle English schools. That is Article 532 of the Orissa Education Code. Therefore, in all the government orders, these 2 provisions have been referred to.
533, 534.
Yes. Oh, yes.
534 does not include.
No, 532 and 533. 532 for middle English schools, MA schools, and 533 for high schools. We are concerned with high schools. Well, now your Lordship may kindly see, so far as Education Act is concerned, manual to go. Your Lordship may kindly see the statement and object of Orissa Education Act. Orissa Education Code is also there in that manual, but full education code is not there. Your Lordship may kindly see
Education manual.
Education manual, the statement and object of the Orissa Education Act 1969, page 107. The statement and object and reasons in this Act 15 of 1969. Educational activities, my lord got it.
107, yeah.
Educational activities in this state were being regulated through the Education Code, which is a collection of executive instructions issued by government from time to time. But action taken under the Education Code has been declared as illegal as the code does not have any statutory support. As a result, it is becoming increasingly difficult for government to fulfill their responsibility for management of educational institutions, conduct of educational programs and directions of educational activities. It is not possible to take adequate and timely measures to prevent mismanagement of non-government institutions. It is therefore considered essential to enact what may be called an Education Act, in which the government will assume the authority for taking suitable steps to prevent the affairs and management of the non-government institution deteriorating. Government will take the authority and other things are there.
What is that? To prevent the affairs and management of non-government?
Non-government educational institutions.
Steps to prevent.
Government will take the authority and responsibility of directing management, administration and...
No. The second paragraph.
Second paragraph. It is therefore considered essential to enact what may be called an Education Act, in which the government will assume the authority for taking suitable steps
to prevent the
affairs and management of the non-government institution deteriorating.
To prevent deterioration of...
Yes, that will be prevented. Government will take the authority and responsibility of directing management, administration and maintenance of teaching standards in educational institution in this state and determining the service condition, etc. of the staff employed in educational institution. The Act also proposes to give authority to government to prevent the management of an institution from abusing or misusing the properties that might have been donated by the people for the purposes of the educational institution concerned. Above all, this Act will help future development of education. Then your Lordship may kindly come to section 27(4). Rule making power, page 165.
Yeah.
The state government, after previous publication, make rules for carrying out all or any of the purposes of this Act. Then 2. In particular and without...
Go to 4.
4. Your Lordship may. Until rules are made under this section, the rules contained in the Orissa Education Code, which were in force immediately prior to the coming into force of this Act, shall, in so far as they are not inconsistent with the provisions of this Act,
deemed to be rules
or of the Constitution, be deemed to be rules made under this Act.
Whether any rules are made now?
Well, rules are made, but so far as Urdu teachers are concerned, my lord, there is no provision under the rules.
Therefore, very consciously, no. That is not the argument. A similar argument was made, I think, in Talaj. Yes, Supreme Court said, once rules are made, you can't say these rules do not cover that subject and therefore the court should... You cannot make that argument.
All right. My submission is, under the rules, my lord, permission, well, there are 3-tier system. First, permission for establishment of a school, that is under section 5 of the Orissa Education Act. Then comes recognition under section 6 of the Orissa Education Act. Then, my lord, the provision for recognition by the board or the examining body like council or the university.
Section 5 is permission.
6 is recognition. 6 is recognition.
7 is?
No, 7 is not there.
6.
Permission and recognition. Then recognition by the board and university and council, that is for the purpose of examination.
Yeah.
without permission, an institution cannot be established. And
after reading that, I understand.
So far as
27(4).
Yes, conditions of recognition, which has been mentioned under Section 6 of the Orissa Education Act, there is a provision that appointments shall be made in accordance with the yardstick prescribed by the state government. Your Lordship may kindly see that. Section 6.
Page 125. 125. 125.
No, your contention, just to understand that one. You want to bank upon this executive inspection, education code.
Yes.
What for?
Well, because my appointment was made at a point of time, that is in 1995.
But that was there.
But that was there.
Yeah.
That was there. 333 was there.
Yeah.
333 was there.
No, not 333. When rules were promulgated?
But the rules were promulgated, well, so far as permission and recognition rules, that were those were promulgated in 1991.
Therefore, prior to your appointment.
Prior to my appointment.
Therefore, you can't go to the executive inspection.
Yes, yes, yes. But I am conscious of that. Only background history, therefore I am saying all these things. Well, one of the conditions for recognition under Section 6 of the Orissa Education Act is, Your Lordship may kindly see Section 6.
125.
125. Conditions for recognition. 129. No educational institution shall be eligible for recognition under 6 unless it fulfills the following conditions. Land, and D, Your Lordship may skip over that fireproof building. Then C is adequate land, playground. D, Your Lordship may kindly come to G. Qualified teachers and non-teaching employees. Manual 129.
You should say subsection clause G, otherwise Mr. G will stand up.
Those things are not necessary.
Yes, just
for the purpose of this case.
No, yes.
Broader view of it.
Yes. 129. Page is 129.
Yeah.
6 say G. Qualified teachers and non-teaching employees selected in accordance with the prescribed procedure as per the prescribed yardstick have been appointed. Here they have used the expression prescribed yardstick, or they have employed the language prescribed yardstick. Yardstick is the yardstick dated 8781.
No. Prescribed yardstick dated?
Dated 8781. That is in that manual also. That is at page 1085. This was issued on 8781. In that manual that is there. Well, there are different types of high schools, 3 class, 5 class and 7 class high school. This is a 3 class high school. Headmaster 1, trained graduate 4, trained intermediate nil, trained matric nil, classical teacher or Sanskrit teacher 1, Hindi teacher 1, PT 1, LDC 1 and non-teaching staffs. There is no post of Urdu teacher.
Yeah.
My lord, after enactment of the Orissa Education Act, although there was provision under the Orissa Education Code regarding appointment of Urdu teacher, since the school is located in a Muslim populated area, therefore the management, this school, the status of this school is an aided educational institution notified under Section 3B of the Orissa Education Act, and it has received full grant as per the granted order of 94. These are all admitted facts.
No, whether Act recognizes like socially backward class area, SC, ST area, etc., like Muslim dominated area.
Well, there is a provision under the Orissa Education Code.
The code goes now.
Yes. So far as Education Act is concerned, educationally backward area that has been taken note of or recognized in the Education Act.
No, since you say the Muslim populated
area, there is no
significance.
Such. Muslim populated area, there is no such provision. My lord, but so far as the present school is concerned, Your Lordship may kindly turn to Annexure 1 at page 17. The school is surrounded by many villages and where Muslim voters or Muslim people population is much more. And it is reflected from page 17, Annexure 1. With reference to
43
yes.
Muslim voters are there.
Yes, yes. And
how many students are there?
Well, at least I had given. That is, you have given so far as class 10 is concerned. Their appearance in class 10 examination.
No. Everything I had given.
Have you supplied it to your friend also?
Yes. Total
enrolled students of...
But I have also given. Right. Yes. My Lord, let me complete, my learned friend will argue. But therefore, there was need of appointing an Urdu teacher, and therefore an advertisement was floated, and selection was also made on 26/8/95, Annexure 2 at page 18. And in the selection, 2 Urdu teachers of nearby high schools.
But this was done by the management itself.
Yes, management was there, headmistress was there, and 2 Urdu teachers of local areas.
All belonging to the school.
No, not all belonging to the school. 2 Urdu teachers of the nearby schools.
No, there are also schools only. No, where is the element of involvement of the government?
Well, government involvement, thereafter I was given appointment under Annexure 3 on 28/8/95. That is at page
95.
Page 19. And I joined on 3/9/95. That is at page 20.
Appointment order is 28/8/95.
28/8/95.
Is it appointment order or engagement order?
No, appointment order.
Appointed as
Urdu teacher. Page 19, Annexure 3. Is appointed as Urdu teacher.
Yes.
That is the language employed. Thereafter, Annexure 4 is my joining letter. Joining report, that is, I joined on 3/9/95.
Is it Urdu school?
No, not Urdu school.
General school.
General school.
Urdu teacher is appointed.
Yes, because some students used to take MIL Urdu.
How many students?
My Lord, that I am coming. Your Lordship may kindly come to Annexure 5. This is the letter of the headmistress. On last occasion, also I have read it out.
In the consonance of the DO.
Because this letter was issued in response to the letter of the district education officer dated 8/3/2018.
What he said?
Yes. In inviting the letter number such and such dated 8/3/2018 of the district education officer Jagat Singhpur, the justification of appointment of Urdu teacher in the school stated as follows: that Parvati Girls High School, that is the school in question, Odasudha, is situated being surrounded by 6 Muslim-based villages: Odasudha, Panaspada, Patana, Mohiuddinpur, Kokulipur, Piteipur and Sampur, Majurai. Presently, this is the first only girls' high school in Odasudha Panchayat, where there is no other facilities for the Muslim girls to have their secondary education with Urdu as the first language. In order to keep the communal harmony as well as the interest of the minority community, initially and unanimously, it was decided by the MC to facilitate the Urdu teaching to the Muslim girls. Owing to the demand of the public and same Muslim well-wishers and founder members of the school, the MC of the school earnestly felt the urgency of appointment of an Urdu teacher in the year by MC Resolution number 56 dated 26/8/95. As the school was running by the private management and patronage of the public, the appointment was made accordingly. Later, the same intimated to the competent authorities, which had not been seriously viewed by them, but the teacher concerned has been discharging his duties regularly in this institution till date. On the other hand, the result of the student has increased. Now the strength of the Urdu learning students have developed in the school, and the service of the teacher has mostly been unavoidable. For the interest of the students and the institution, justification of appointment of Yaqub Khan, Urdu teacher, the present petitioner, Parvati Girls High School, Odasudha, may kindly be considered. Thereafter, my Lord, A proposal was also sent.
That letter of district education officer.
Yes, this is
8/3/2000. What is that letter?
Well, at 8/3/2018, well, this is reply to the letter of the district education officer dated
What
8.
was that letter actually?
Well, that letter I have not annexed.
No, that's necessary.
Yes, yes. My lord, I will give. My lord, Annexure 6 at page 22 may kindly be seen. Then, my lord, a proposal was sent for approval of my appointment as Urdu teacher and to release grantinate in my favor as per the grantinate order of 94, that is on 7/8/2018 under Annexure 6. Thereafter, several resolutions were passed, that is in vernacular. I will not take your lordships to all those documents. Thereafter, my lord, I approached the State Education Tribunal by filing a GIA case.
Which came to be dismissed.
No, not dismissed. My lord, that was disposed of, directing the director to take a decision in the matter. Then the director rejected my case on the ground that there is no provision of Urdu teacher under the yardstick. And since your appointment is not admissible, you are not entitled to get grantinate. Well, that chapter was over. Thereafter, my lord, a ray of hope came by issuance of a government order that is under Annexure 7 at page 47. Your lordship may kindly see the subject. Here they have also referred to Article 532 and 533, which I have shown to your lordships. Subject: contractual engagement of Urdu / Persian teachers working in aided high schools. Ours is aided high schools. Block grant high schools has resource teachers in the said high schools. As per Article 532 and 533 of the Orissa Education Code, there is provision to provide Urdu teachers in secondary schools where sufficient Muslim students are desirous of reading the subject. There is no Urdu / Persian teachers as per the yardstick for secondary school as prescribed in EOS department letter, that is 8781, that is wrongly, my lord, written 7881. However, the managing committee of sub-aided high schools / block grant high schools have appointed Urdu / Persian teachers in their schools, keeping in view the requirement of such teachers for Urdu language students who are continuing beyond approved post without grantinate. Government, after, this is important, government after careful consideration have been pleased to decide engage 10 Urdu / Persian teachers working in existing 10 non-government aided high schools and 13 Urdu / Persian teachers working in 13 block grant high schools as per list Annexure 1 as resource teachers on consolidated monthly remuneration as would be decided by government under the following terms and conditions. My lord, thereafter,
what are the terms and conditions?
My lord, that is not there, but that is in the other circular. Your lordship may kindly turn to next page, page 48. The list of 10 teachers. All these teachers were appointed. One in 93, one in 85, one in 82, one in 94, one in 95, one in 92, 94, 92, 93. And they also got the requisite qualification thereafter, that is Alim or Fazil, in different dates. They were engaged as resource teachers. Thereafter, another list is there at page 49 relating to 13 teachers, and their date of appointment is also prior to, that is 2003, 98, 97, 97, 94, 95, 93, 98, 2003, 96, 95, 2003. And they also acquired Alim and Fazil qualification subsequently. Thereafter, my lord, your lordship may kindly turn to Annexure 9 at page 50. The state government called upon the director to intimate about Urdu teachers working in different high schools. Sir, I am directed to invite reference to the subject cited above and to request you to kindly furnish following information to this department early. 1. The district-wise and school-wise enrollment of Urdu students in government high schools, in fully aided high schools and in new aided erstwhile block grant high schools during the year 2015-16 and 2016-17. the district-wise and school-wise sanctioned post of Urdu teachers in government high schools, the district-wise and school-wise Urdu teachers adjusted as resource teachers in fully aided high schools and in new aided erstwhile block grant high schools, this may be treated as most urgent. Pursuant to this letter,
this was Joint Secretary to Government.
Yes, pursuant to this letter, Your Lordship may kindly turn to next page, Annex 10 series at page 51. District Education Officer writes to the Director Secondary Education Orissa, indicating the details of Urdu teachers, wherein Your Lordship may kindly come to page 52. Information regarding enrollment of Urdu teachers and posting of Urdu teachers in high school. So far as the petitioner school is concerned, that is at serial number 1, Parvati Girls High School, fully aided. Then class-wise roll strength of 2015-16 and 2016-17. That is there. Thereafter, my lord, the rejection order. My lord, I approach this honorable court by filing a writ petition that you consider my case for engagement as a resource teacher. That writ petition was disposed of, that is 21872 of 2021, that was disposed of on 3/8/2021. I have quoted that order. Your Lordship may kindly come to page 10.
Yes.
Page 10.
Consider the
representation. Thereafter, they rejected my case by virtue of this order, which is under challenge in this writ petition, that is Annex 12 at page 56. Para 3. On 2 grounds they have rejected. The first ground is the post is not within the yardstick dated 8/7/81. And second ground is, well, they say that I don't have alim or fazil qualification. But in fact, I have.
You acquired as on which date?
Well, I acquired alim qualification on 17 July 2008 and Fazil, which is higher qualification, that is on 2/6/2012. Either alim or Fazil is necessary.
Now, as on the date of appointment?
Date of appointment, I don't have.
Did not.
And so far as all these resource teachers who have been subsequently engaged as resource teachers, they have also acquired alim or fazil qualification subsequent to their appointment.
No, that makes no sense.
Well,
as on the date of appointment.
Well, now the date of appointment is irrelevant in the sense, but my lord, the government floated the order way back in the year 2012 itself. So prior to 2012, I have already acquired alim qualification. That is on 17 July 2008.
Some are in 2000, subsequent 3, etc.
Yes.
No, subsequently also. Subsequently also.
Fazil on 2/6/2012. Any one of the qualification is necessary, not Fazil.
Both.
Yes, only either alim or Fazil.
Will come back.
Yes.
Let us see, we are in the middle of the hearing now.
Wait. That's that item that 42. None is near the advancing element. In that case, I am appealing for the managing committee. Okay, number 4.
Yes. You support or you keep a distance from the petitioners?
No, he supports.
You support. Yes.
Well, I have shown to your lordship that government order dated 26/4/2012 I have acquired alim qualification on 17 July 2008.
How many petitioners there?
Only one petitioner. Only one petitioner.
This is policy.
The first policy was issued.
And you acquired alim?
Alim qualification on 17 July 2008. The requirement is either alim or fazil.
Okay.
I have acquired both the qualification, but fazil later on, that is on 2/6/2012. Alim is equivalent to BA, fazil is equivalent to post-graduation. My lord has already seen the government order dated 26/4/2012, where the government took a decision to engage Urdu teachers as resource teacher with a consolidated remuneration, subject to certain conditions.
Sufficiency of students.
Yes. The student, my lord, there is no condition of student.
No, otherwise without student?
No, not without student. But, my lord, so how many students are to be there? That is not there.
That is left to the, that is not there is true.
Yes.
But certainly in vacuum
there are
can be
students.
appointed.
Yes. Without students, teacher cannot appear.
Question is, how many students will, that question will appear?
Yes. My lord, I will come to that. Your Lordship, kindly see Annexure 14 at page 61. The second policy decision that has been reiterated on 29/6/2018.
A, B, C, D, E, F.
Yes, Your Lordship, may kindly see. A, the qualification of Urdu stroke Persian teachers to be engaged as resource teachers should be alim stroke fazil.
That you.
Then, yes. Then B, role strength of the school must justify for engagement of resource teacher in the said high school.
This is
role strength is there. I will show to your lordships. Then, my lord, basing upon this government order dated 29/6/2018 under Annexure 14, your lordship may kindly come to page 63. 16 teachers, their date of appointment is subsequent to me. They were engaged as resource teachers, having alim or fazil qualification.
In which schools? Different schools.
Different schools. Page 63.
What is the student strength there?
But student strength, it has not been written. Yes. But I will come to that. I will satisfy your lordships. Then your lordship may kindly see the another government order.
No, many are appointed is true.
No, but with the same terms and conditions. Annexure 3 government orders were issued. One in 2012, one in 2018, and another in 2011. With same terms and conditions, with a consolidated remuneration of 7,400 per month.
2021.
22/12/2021, the latest. Now, your lordship, may kindly come to the role strength of Urdu students. That is, I have annexed under Annexure 13 at page 60.
In your school?
Yes, in my school. Because, my lord, after the Compulsory Education Act 2009 came into force, my lord, so far as class 8 is concerned, that was added in upper primary school. The definition of elementary school in Compulsory Education Act, that means class 1 to 8.
1 to 8.
Previously, it was in high school. Class 8 was in high school. 8, 9, and 10, 3 classes were there. Now, 8 has been added to upper primary school or any school. And that comes under elementary schools. So far as high schools are concerned, only class 9 and 10.
Yeah.
And here, my lord, I have given the role strength of minority students or Muslim students under Annexure 13 at page 60, starting from 98-99. My lord, your lordship may kindly see from 2011-12, when that circular came into force, when that government order came into force. My lord, class 8, 7 students, class 9, 13, class 10, 9, 29 students were there. 2012-13, class 8, 9, 11, class 9, class 10, 11, 31. 2013-14, class 8, 7, 16 in class 9, class 10, 11, 34.
Anyway, numbers.
Yes, numbers I have given. And my lord posed a question.
How many were made to sit in the 10th exam?
10th examination. My lord, now my learned friend has produced the same. Your lordship may kindly see that. Because from that is in their instruction they have given. The last three columns, number of Muslim students of class 10. Your lordship may kindly see 2011-12, 9, 8 appeared, 4 passed. Then 2012-13, class 10, 11, 10 appeared, 8 passed. 2013-14, 18 students were there in class 10, 11 appeared, 11 appeared, 11 passed. 2014-15, 16 students were there, 15 appeared, 14 passed. 2015-16, 11 students were there in class 10, 11 appeared, 11 passed. 2016-17, 8 students were there, 8 appeared, 6 passed. 2017-18, 9 students were there, 8 appeared, 7 passed. 2018-19,
4 appeared, 4 passed.
Yes.
Then 3 appeared, 3 passed.
3 passed.
10
Then
appeared, 10 passed. 4,
yes.
3.
Yes. So admittedly, in each and every year, my lord, the students who have taken MIL as Urdu was there in the classes. And this is
the management pay. Why government should pay?
But because
you have, if at all, it is not that the government is against Urdu education. There are schools, district level schools. At the district center?
Yes.
Yeah, you go there and
this is an aided high school.
Aided high school is not in respect of this.
No, my lord. The policy decision has been taken in respect of aided schools.
Correct.
But
there are sufficient number of students. Suppose if only chosen few. Kindly see.
No, my lord. This is in
3, 4.
No, this is in respect of class 10. This is in respect of class 10.
Correct.
Now, my lord, there are 2 classes, 9 and 10. After the Compulsory Education Act came into force. Well, therefore, under Annexure 13, I have given the entire roll string for class 8, 9 and 10. That is, number of students are there. Your lordship may again see Annexure 13.
Yeah. After all, Supreme Court said,
yes,
the Right to Education Act is not applicable to minority institutions.
Yes.
There are minority institutions, linguistic
minority institution.
No, there are.
There are minority institutions. No, but so far as nearby areas are concerned, but there is no minority institution for
nearby means in
but in that Gram Panchayat there is no school. You also kindly see this.
No, it is the nearest school.
Well, the Sarpanch has given a certificate. You also kindly see that.
Yeah.
My lord, may kindly see page 46.
Saying,
certified that Parvati Girls High School, Odasudha, is situated being surrounded by 6 Muslim-based villages.
Yeah.
Odasudha, Ponaspada, Patana, and so many villages. Presently, this is the first and only girls' high school in Odasudha Panchayat. There is no other facilities for the Muslim girls to have their secondary education with Urdu as the first language.
We are not against your studying Urdu, you are studying Arabic, you are studying Latin, Roman,
yes,
any language of your choice.
Yes, yes.
There are other schools where these languages, this medium.
These languages are not taught. But so far as this is a general high school. Well, this is a general high school. Now it has been converted to
bilingual high schools are there.
No, not there. Well, now it has been converted to co-education school. Previously, it was a girls' high school. Now, my instruction, it has been converted to co-education school. In co-education, because of since it is a girls' high school, only girl students used to take admission. So, therefore, roll strength was low in respect of Urdu subject. Now, since it has been converted to co-education school,
with effect from?
Co-education
with effect from which date? It became co-education.
It has now become, it has take instruction to that effect.
Not for the call, it's a phone line. Phone a friend. That's all.
Phone. So, my lord, in all these schools where these resource teachers were engaged on the basis of the policy decision of the state government of 2012, 2018 and 2021, roll strength was, my lord, virtually equal to the petitioner school, because there is no specific roll strength as mentioned in their policy decision. Where Urdu teachers are, where Urdu students are there, for them, since they are taking MIL as Urdu, therefore there is necessity of Urdu teacher, and government in its wisdom have decided to issue the policy decision of 2012, 2018 and 2021. And this teacher is serving since 1995 continuously.
That's good. You extract money from the management.
But management, since it is an aided, fully aided high school, where from they will give?
No, then they should not have taken it.
But because these policy decisions are only meant for aided schools, not for government schools. Your Lordship may kindly see 2012 first, the heading. Page 47. Subject: contractual engagement of Urdu / Persian teachers working in aided high schools / block grant high schools as resource teachers in the said high schools. Then your Lordship may yes. Then your Lordship may kindly see the subsequent circular, that is Annexure 14 at page 61. The subject is same. Contractual engagement of Urdu / Persian teachers working in new aided erstwhile block grant high schools as resource teachers in the said high schools. Then 2021 circular, the same language, Annexure 15 at page 68. Subject: contractual engagement of Urdu / Persian teachers working in new aided erstwhile block grant high schools as resource teachers in the said high schools. Well, I am claiming parity with them. When similarly situated teachers who were also there prior to coming into force of the policy decision of the state government in the year 2012, and they were favored with engagement as resource teacher, well, why not the petitioners shall be extended with that benefit? He is claiming parity, and he has got the requisite qualification prior to 2012, and he has also got the higher qualification of Fazil, because he has passed Fazil in 2012. And my case was, so far as the ground of rejection, even if applying the ratio of Mahendra Singh Gill, they have not whispered anything about the roll strength. They have only said that since I don't possess the requisite qualification and I have claimed for grantinate as per the grantinate order of 94 and pursuant to the judgment of the State Education Tribunal, my case was rejected by the director. So therefore, I don't have any case. Your Lordship may kindly see the impugned order. Have they whispered anything about the roll strength? That because of low roll strength, we have rejected. That is rejection order.
Annexure 12.
Annexure 12.
56.
Page 56. My Lord, I am just placing. Para 3. Whereas at present there is no provision of Urdu teachers in non-government high schools in the yardstick dated 8781. That is gone because after their policy decision came. Then para 4. Whereas White School and Mass Education Department order number such and such 26/4/2012, 13 Urdu teachers appointed by the managing committee in 13 erstwhile block grant high schools were adjusted as resource teachers with consolidated monthly remuneration. Whereas these Urdu teachers have been adjusted as resource teachers with the following terms and conditions. A. The qualification of Urdu / Persian teacher to be engaged as resource teachers should be alim / Fazil. B. Roll strength of the school must justify for engagement of resource teacher in the said high school. C. The resource teacher will be...
What is this meant by roll strength of the school must justify for engagement of resource teacher?
There is no minimum strength prescribed.
At least we'll ask them.
Yes, my lord.
What is that roll strength which you are speaking of? It is like a Sphinx Mugdha Mauna.
Yes.
It does not say anything.
My lord,
What is
that's
the
what-
minimum roll strength?
Yeah.
My lord, minimum roll strength in the elementary schools, it is the PTR norm is 30:1.
That is in elementary school.
Elementary schools. So far as high schools are concerned, my lord, it will be minimum will be 30. 30 students required.
Where is that?
That is in.
It is, yes, it is there.
That
It
is total students in class 8, class 9 and class 10. That is in section 11 of the Orissa Education Act.
Take that.
That is relating to total student, including other category. Not only for Urdu. Section 11, your lordship may kindly see.
Minimum.
Minimum student for each standard, not for Urdu.
Then suppose if for Urdu there is only one candidate.
One student.
Separate teacher.
And your lordship may kindly see section 11. Pupil strength. The private educational institutions pays 152. I don't know.
No.
Huh? Means 150. My lord got it.
152.
Yes. Pupil strength. The private educational institutions shall have minimum roll strength of pupils for each standard or class as hereinafter provided. In the case of colleges, we are not concerned with. Then your lordship may kindly come to 11.3. In the case of high schools, the minimum roll strength of pupils for each standard or class, that means class 8, 9 and 10, shall be 30, which shall be 20 if such schools are located in scheduled areas.
Yeah.
30 means not only Urdu students alone.
All other students.
Including other students.
That now we are asking you.
Yes.
In that, what should be the percentage?
Well, percentage. Total number 30 students.
Correct.
The school has more than 30 students.
Yeah. No, we are asking you.
Yes.
Should be the minimum number of Muslim students in the.
That has not been stipulated anywhere.
Even if one student comes,
No,
what are you going to say?
I don't say that for one school, for one student, a teacher is necessary. Well, I am not saying so. But now your lordship has already seen Annexure 13, where I have given the roll strength. There is no question of one student.
No. What should be the ratio? It should be normative.
Yes, it should be normative.
Normative.
Normative. Absolutely correct.
Normative.
Absolutely
What
correct.
should be the according to this? What is according to sufficient must justify for engagement? What is that? Strength of the school must
Nowhere it has been prescribed.
or engagement of resource teacher in the said high school.
Nowhere it has been
Teacher
prescribed.
means naturally it has to be by Muslim students.
Well, it's some Muslim students
and nobody else.
No.
Well,
This is a general high school. This is not a minority institution.
Correct. But class B, 5B relates to the Muslim students only.
Correct?
Class 5B.
No, 5B.
Annexure, page 50. Kindly come to 57.
57, yes. The roll strength of the school, 5B, must justify for engagement of resource teacher in the said high school. Well, how many students it has not been considered? Well,
there is only one Muslim candidate.
No. Well, your lordship's question is absolutely correct. If one student is there, certainly there is no necessity of Urdu teacher.
Correct.
Or resource teacher.
What should be
the... Since nothing has been prescribed, and as per section 11 of the Orissa Education Act, the total number of students in class 8, class 9 and class 10, minimum is 30.
Yes.
And here, you will also kindly see Annexure 13 again. Because if calculation is made from 2012 onwards, here total number of students, Urdu students, how many have appeared in HSC examination, that is immaterial, 29. 31, 34, 35, 22, 22, 20, 19, 12, 7, 14, 15. So adequate number of students are there.
No, it is not there. Provision that one adequate.
What does it mean?
More than one. Will it be?
No, I am not saying that one.
One student is there for examination.
When the pupil strength as per Orissa Education Act, which is a
Education Act,
which is a mandatory provision,
11 subsection 3 speaks that roll strength of each standard or class.
C standard means class 8. 30 standard means class 8, class 9 and class 10. High school comprises of 3 class high school, 5 class high school and 7 class high school. If it is a 3 class high school, then each standard means class 8, class 9 and class 10. If it is duplication, class 10 and class 10B, then if it is more than 55, then another petition
is necessary.
Irrespective of section,
at the time of appointment of the petitioner, there were no students.
That is not necessary because 2012 year
that is necessary.
Policy came 2012.
At the time of appointment, you have no Muslim students.
Then the post was invisible. My lord, all high schools where Urdu students were taking Urdu as a subject, my lord, they have appointed Urdu teachers. The ray of hope, my lord, that arose in the year 2012 when the government brought out a circular for engagement of these Urdu teachers as resource teachers.
Sufficient number of students.
Yes, sufficient number does not mean it will exceed 30. Total number of students in class 8 is 30, including Urdu.
That argument will take me to the extreme. Both you are operating on the pendulum of the clock. And especially the pendulum of the crazy clock.
Yes.
Which will strike 13 for the 1 p.m. And that will create doubt not only about 13 stroke, but earlier assertions also.
If the intention of the legislature was in respect of a particular subject is 30, then they would not have used the expression standard or class. That is, your lordship may kindly see section 11 again.
11.3.
11.3.
Of course, it uses the word standard or
Because on subject-wise teachers, my lord,
the subject-wise teacher, there is no
my lord, there is
confuse the code.
There is a role
confuse the code.
My lord, there is a prescribed 8781 yardstick is there.
That is for duplication. Your lordship,
it is not duplication, my lord. The 8781 yardstick, your lordship may kindly say.
Yes. Your lordship may kindly see that.
Though why I am hearing it so long is that will be the law for all other cases to come hereafter.
Yes, absolutely correct.
Yes. And that will put the extra burden on the exchequer.
Well, here extra burden, your lordship may kindly see what they are paying. 7,400.
Even 1 rupee, it costs from the exchequer.
Yes. I don't say that it is not coming from the government exchequer. It is coming from the government exchequer. But your lordship may kindly see the yardstick my learned friend is referring to.
And once we allow this, the next case will be we are also teachers on par with rest of the teachers. Therefore, we should be given the same salary which is being given to them.
But
next will be that one.
But that question will not arise because this is confined to only schools where students who are taking Urdu as subject, who are being taught in Urdu. Not in so far as general schools, most of the general schools, they don't have any Urdu teacher. Only where Muslim population is much more, surrounded by some villages and Muslim population, in those schools, requirement of a Urdu teacher is justified. So therefore, my lord, your lordship may call for, so far as all these schools are concerned, what was the role strength?
In
where resource teachers have been engaged.
Mr. G,
my lord,
as he rightly says, in other schools, wherever you have granted that 7,400.
What was the role strength?
What is the role?
I will bring that, my lord. I'll bring that.
That will be the...
That will clear the issue.
Matter was heard again. On 2 occasions. Though it appears to be very innocuous, it has several implications and consequences. First of all, the latest office order dated 29/6, no, that is 21 is which one?
Well, 21 is 22/12/2021, Annexure 15.
2021 at Annexure 15.
One teacher
Stipulates one of the conditions as stipulates roll strength of the school as one of the conditions. First of all. However, what is that strength is not mentioned. First of all. Both the sides banked upon the text of Section 11(3) of Orissa Education Act 1969. First of all. That speaks of standard or class.
Yes.
And it has nothing to do with the subject, language, stroke subject. Yes. Namely, Urdu, herein. First of all. In view of that, it is necessary to learn as to what is the strength of Urdu students,
minimum,
Urdu students in all the schools in the state.
Yes.
Wherein the Urdu teachers are appointed as resource teachers, trying ₹7,400
per month
as the remuneration, lump sum remuneration. First, learned AGA to furnish this information at the earliest. First, it is open to the petitioner.
Yes.
To do his exercise as well.
Yes.
Call this matter for further hearing in the third week of October, 2020. Very interesting points are in.
Yes, yes.
I'm not much bothered about one case.
Yes.
It's consequence. Potential to generate litigation.
Yes, yes.
That I am worried.
Yes, yes. Well, I'm conscious of that.
But as you rightly said, it cannot
far-reaching
be 30. It will have far-reaching consequences.
Yes.
Yes, possible.
Item 36.
Well, I have already OUT counsel. The opposite party, I have already soft copy.
I have soft copy. If your lordship permits, I can take instruction in this matter.
You have third copy now?
Yes, just now.
Tomorrow, you
know, next week.
Call immediately after vacation.
No, well,
why? What is the urgency?
Well, the petitioners served, they are unemployed, they have terminated from service, their salary was not.
Well,
the project was closed and their service was. The arrears are. Only, my lord, actually, representation, only your lordship, representation are to be disposed of, let them serve tomorrow or Monday.
My lord, may call this matter next week so that I can take instruction.
Monday.
No, what is the urgency? Yes. If it is really urgent, we will take up the matter. Where is the urgency?
Not the petitioners are the arrears salary.
They will get that.
Next week, your lord.
Next is difficulty.
My name may be
reflected in the cost.
Registry to print the name of the net council. Next.
No, I will try it next week.
Item 43.
Yeah.
That matter will the student results have not declared. Therefore, lordship was kind enough to.
Results were not declared. The college said that they have not posted the result at all.
Nonetheless, the inboard city says declared, but that my lord, senior has also convinced that party. Only your lordship.
Yes, Mr. Patil.
Your lordship had directed me to take instructions as regards whether that could go for a revaluation or not. My instruction is we don't have provisions of revaluation. Only re-examination is there. So if your lordship directs that way, then it's all right. But if your lordship thinks of revaluation, then your lordship has to state that in peculiar facts and circumstances of the case, petitioners, without treating it as a precedent. Oh, I confine to the petitioners only.
No, you mean to say that valuation is not done at all?
But my humble submission, they have not properly evaluated they have not shown the answers.
Where are the answer sheets?
Answer sheets were not called for, so I have not got it.
No, whether valuation is done now?
Valuation done. Yes, but
when valuation was done?
The valuation was done admittedly late. And this is the excerpts of the abolition register where these 9 petitioners have been declared as failed. And the prayer in the petition is as regards publication of the result, and result has been admittedly published. Because the college says,
college may say so many things. And conducts the examination. University conducts.
And university also says, university.
No, they are producing it.
Now, I also filed an affidavit where the university.
You produce the answer sheets on Monday.
Yes.
I will see the answer. If they are valued, then everything is over. Where is the other question?
Yes.
Yes.
And because of the delay, they have
for delay is another cause of action.
Yes.
Question is whether examination valuation is done.
Therefore, last time your lordship was kind enough to say that revaluation and in the eventuality we can may appear.
See. No provision for revaluation is one thing. Number 2, suppose some papers are not valued at all. It is not a case of revaluation. It's a case of virgin valuation. Some answers are not valued. Then it's a case of valuation. Revaluation is not provided for. But valuation they are bound to.
Yes.
If they show that valuation has been done, rest of the things will follow.
Monday,
Subject panel counsel. Patna is requested to produce the answer sheets of the petitioners to vouch prima facie that they have been evaluated. Yes.
Your lordship will following it on
Monday. Saturday?
No, your lordship may call it on Wednesday because in the meantime, if it doesn't reach, it will be embarrassing on my part to ask for.
Wednesday.
At 2 p.m. and his.
2 p.m.
Item 44.
Yes.
Item 44. There is a plea, my lord, I am to file a counter. There is a rejection order at Annexure 10.
File counter in time. 3 weeks finally for filing the counter, if any.
Matter relates to regularization of service of petition.
Very
physical education.
3 weeks after 3 weeks ago.
Item 46. Item 46.
Your lordships, we filed an intervention application. However, the petitioner was not kind enough to accept it. He insisted to accept. We had offered it. Precisely matter.
I will take instruction and I will file objection. Who is he and
immediately after vacation?
Yes, your lordship.
At the request of counsel appearing for the petitioner, who seeks to file objections to the intervention. Next. Interim order to continue till next date of hearing.
Item 47.
Yeah.
My lord, my original mark sheets and certificates are withheld by the school on ground of outstanding fees, my lord.
Fees not paid.
Fees not paid.
But you have to give the fee now.
That is okay, my lord. But the reason was the petitioner's, the candidate's father, his wife is suffering from blood cancer, very serious condition, due to which he was having financial issues. And he approached the school and said ki, the amount of 1,60,000, you may please divide it into installments. I am paying 70,000 upfront now. Kindly release the mark sheets and certificates.
Tomorrow, if you take the mark sheet and you will not pay remaining amount, what they should do? You will give you installment. Okay. You pay entire money and I will give you the installment also. Then last installment when you pay, they will release the mark sheet.
My lord, but that is from last year onwards. They have
by now generated. Otherwise, how the university should function? Already he was complaining. You are directing regularization where from we should make the payment. Government is not paying. That was his submission in two matters. Therefore, whatever fee is prescribed, that has to be paid. We will give you time.
My lords, here is a case where the prayer is against the school. I appear for the CBSE. We have already sent the original mark sheet to the school.
School has to, you have to remit money to the school. Fees has to be paid.
My lord, last year the certificates were not released, and this year admission form the candidate has filed for +3, and intimation is also available that he will be taking admission. From the
when is the admission date?
Submission of original mark sheet for verification was on 11th/9. For by giving request, the admitting college have extended the timeline to 22/9.
Do you have any property?
I have to ask for yes, my lord. He may have, because he is a farmer actually.
Farmer.
Yeah.
You give the mortgage of that property for the money. I will permit you to take the certificates. Now 60,000 you are paying.
70,000, man.
70,000 you are paying. Remaining amount is
90,000. 90,000.
90,000. That 90,000 you give undertaking to this court. And encumber your property in favor of the Registrar General of this court, so that we will sell that property and give that money in the event your client does not pay.
Sure, my lord. I have to take that instruction from the petitioner.
When to call?
Tomorrow.
Tomorrow.
But the school is, though school is a party here, but school has not been represented by any of our lawyer brothers.
It's your school.
No.
Affiliated to you.
Affiliated.
The school is not represented.
It's a party, but probably notices.
No notice was sent to school.
No, my lord.
You have to issue notice to the school, na? You are remitting that money to the school only.
Yes.
School is a necessary party. There is a famous judgment by Lord Coke, Bentley's case, where university was interested in taking money. So it has to be, it's a necessary party. Very old case which we were taught in administrative law more than 35 years ago. Bentley's case, very famous judgment. Bonham's case, two cases are there. Can anybody take out those cases? Bonham's case is, I think, 1700 odd it must be. Therefore, let us issue notice, issue emergent notice to the OP school.
1 and 2.
1 and 2. In addition to taking usual steps, the petitioner to take dusting. So the dusting procedure is here?
Yes, ma'am. Yes, ma'am.
Dusting as well. And submit compliance to the registrar.
My lord, we have filed one IA for protection of admission, my lord. That by the time we provide the original mark sheet, the admission should not get disturbed.
Where you have to take admission?
Rusikesh Degree Mahavidyalaya.
But that is not the party here.
Definitely, my lord, because at that time intimation comes from the slot allotment basis. That was not available at that time of
an application the petition, supported by an affidavit seeking reprieve. Since the closer date for admission in which is that
ऋषिकेश डिग्री महाविद्यालय.
Rishikesh Degree Mahavidyalaya is fast approaching.
ऋषिकेश राय.
Rishikesh Roy Degree Vidyalaya. First, Learned Counsel for the petitioner submits that if the marks cards are not produced in time, he may forfeit the possibility of getting admission. First one. Next one, in the above circumstances, the Rishikesh Roy Degree College,
Degree Mahavidyalaya.
Degree Mahavidyalaya is requested to keep one seat. Which seat it is?
+3 political science honors.
Plus political science. Vacant. Till next date of hearing.
My lord, this college may be added as a party.
No, not necessary. Just they carry this.
Okay.
This order to be obeyed by the said college as if it is a party to the proceedings. Proceed. Come on the production of copy of this order.
My lord, that college is coming under Department of Higher Education, Government of Orissa.
Let us see.
No.
You just carry that. Your question immediate. Well, we'll call this matter on Monday.
Sure.
Monday? All right. Call on Monday. In the meanwhile, you serve copy and come back. Okay. Whether that college has got email address.
That I have to see. But we have people who can serve this order.
Serve that one. All right. On Tuesday, we'll call this. Okay? Tuesday. Call on Tuesday.
Item 48.
Registry send a copy of this order by speed post immediately to the said college.
Petitioner pays for quality
for the board.
Last occasion of take instruction for that. Petition prayer is pay for correction of his petitioner father's name, my lord.
Your father's name to be?
Matric certificate and matric mark sheet.
Some initial to be struck off.
One H is added.
H is added.
Last occasion take instruction for sign.
Remove H.
Yes, madam.
The short grievance of the petitioner is as to wrong mentioning of his father's name in the
matric mark sheet and certificate.
In matric
mark sheet, manner. HSC mark sheet.
Mark sheet.
Matriculation
mark sheet.
As well as certificate.
And other certificate. First off, Learned Counsel for the petitioner submits that the true and correct name of his father is, what is the correct name?
Padaneshwara. Padaneshwar.
Padaneshwara.
My lord.
Only Padaneshwara.
Padaneshwara Muduli, my lord. Muduli.
Right now. Whereas the certificates contain the wrong name.
PADANESHWR. Only H is added. PADANESHWR. Padaneshwara Muduli. Only H is added.
It should not have been added.
H is deleted, my lord.
The letter H, counsel submits, has been wrongly added to the name, and that needs to be removed. First up. Next one. Learned panel counsel appearing for the Board of Secondary Education. Having resisted the petition for some time, now agrees with the suggestion of this court that the board shall issue the rectified certificate stroke marks cards within a period of 10 days. Issued within a reasonable time. If the petitioner furnishes the requisite documents to vouch the correct name of his father. First, with this proposal, petitioner is agreeable. Counsel for the petitioner is agreeable. Next paragraph. In view of the above, petition is disposed of, directing OP numbers, OP number 2, to correct the name of petitioner's father, and issue corrected original certificate, that stroke marks cards. After collecting back the ones that have already been issued to him, you have to give back those marks cards. First, time for compliance is 2 weeks. Within 2 weeks, you should do that.
Marks card and certificate, original certificate.
And certificate.
And certificate, man.
Into brackets, original. No.
Item 49.
Yes.
Item 49, on behalf of last month, let the matter be adjourned to some other day. Not him. He will not go. No, he will not go.
Morning, he asked me to go.
He will not go.
Just to remind my lord, see that matter was connecting that review.
That review was dismissed, but the other cases were before mine. I am also there.
That has gone to apex court now.
Yes, that the update is here with us now. But this is the matter connected to those matters, no?
Those cases, my lord, have held that review is not maintainable against the order. But this is something.
The whole thing.
Yes, I will say I am ready in court because my learned friend is.
We need an update hearing in the matter.
Okay. Which date, whichever date you want to.
After vacation, then after vacation, let you complete it.
Very difficult. Very difficult.
So maybe on 9th, 8th or 9th?
We have already posted matter, call this matter on 13th.
Yes, can be 14th, my lord.
14th. That day, you should.
Yes, today also I am because my
date is chosen from the calendar by learned counsel, Mr. Dash, appearing for the petition. Yes, again, you should.
Sir, binding us to the calendar and then we cannot depart.
Otherwise, what happens is, I have to read and then again matter will be adjourned that way.
That's a difficult.
No, they also again.
Yeah, because one set of matters are already disposed of.
No, that is in a different context.
That does not say that this is also
This has nothing to do.
Item 50.
Yeah. 50. Yes.
This state appeal.
My lord, last occasion, my lord has specifically directed him to take instruction.
Yes.
So far, this present petitioner is concerned about his status and approval, and so far this appointment is concerned. To that effect, I have received the information. Though it is not in the form of affidavit, I can I have supplied the copy. It is from 83-84 minute.
What is the prayer? You want to set aside the order of the tribunal?
Yes, ma'am.
What tribunal says?
Tribunal said that you release Rantinet in my favor.
Where is the tribunal's order?
Madam, that is annexure page 20.
Page 20?
Madam. Page 20.
Page minute, page 20.
Thanks. Page 30 is the update.
1st June 1988, the effective date of salary. They have given it with 1st June 1989.
89. The only dispute, my lord, that that's Lawrence Tribunal come to a finding that since post admissible with effect from 1983-84, the person is eligible to get Grantinet with effect from 1/6/1988 by calculating 5 years from the date of creation.
Which is that rule?
Well, that is as per the principle of the Grantinet principle, though they have not enclosed in the appeal, which was relied by the Tribunal.
Roman I, my lord. Colleges in advanced area will receive 1/3 of the deficit as granted after 5 years from the date of government concurrence, recognition, 2/3 after 7 years, and full after 9 years.
So here granting aid was extended when?
1689 in my favor.
Is it 1/3 or full?
1/3.
Huh?
1/3.
1618. Where is the finding?
Finding, my lord, at
Finding at page
internal page of the judgment 16. 36.
That was in the light of Bilasini Sabu judgment.
My lord. But that principle I have given, the granted principle, that is also clear, my lord. That 83 principle of granted principle.
It should be from the date of creation of the post and not the date of appointment.
My lord.
Because the words is the other day you said that persons.
Person, that is for the calculating qualifying period.
Qualifying.
But it is from the date of creation. That is why my lord directed on last order 18/7, you obtain instruction when the post was created. And now they admit that post was created 83-84.
83.
So that is
5 years from that date.
So tribunal order is that there is no wrong.
Where is the case for you?
There is no wrong.
My lord, on that occasion, it was not available. For that, my lord has specifically directed twice on 14/8/2025 to call for this information. That I have supplied them.
In view of the instruction, my assumption there is no wrong in the order of the tribunal.
And earlier to that, she was in Dharamshala Mahavidyalaya and got the appellation in 83-84.
Certificate test to us.
This appeal is dismissed on the approving the regions assigned by the tribunal consistent with the circular dated
17th March
17/3/1983 issued by Government of Orissa, which says that colleges in advanced areas will receive 1/3 of the deficit as granting aid 5 years after the date of government's concurrence bracket recognition, comma, 2/3 after 7 years, and full deficit after 9 years. First stop. Admittedly, petitioner was appointed with effect from 1 June 1988.
No, my lord, 26/9/83. I was appointed, my lord.
6/9/83.
My lord.
83. And therefore, the tribunal has rightly directed the modification of effective date of approval orders under Annexures 6 and 7.
Before the tribunal.
Huh?
Before the tribunal, Annexure 6.
To the appeal memo of the OP under section 24B of 1969 Act. And held entitlement of the petitioner to the grant in aid with effect from 1/6/1988.
88, my lord.
And not 1/6/1989.
My lord.
89. First time. This view accords with a division bench decision of this court in Bilasini in OJC number 2901 of 1990 between Srimati Bilasini Sahu versus State of Orissa, disposed of on 7/5/1992. Yes. Nice point. Within what period you are doing the compliance? Now so many years have gone.
My lord.
Absolutely unmeritorious appeal.
3 months.
Huh?
3 months.
The direction of the tribunal to be complied with within 8 weeks.
My
8 weeks. Failing which it is open to the respondent to move application for taking punitive action against the officials, errant officials,
my lord.
which may include levy of exemplary costs payable personally by the officials. Okay. Next.
Item 51.
This is that matter where it's squarely covered by a judgment of the coordinate bench. Last time also heard this matter. I have given a date chart as well as that judgment. The copy of this judgment also I have given to the it is also in the file.
Just, sir, refresh my memory.
Yes.
Yes.
Well, this Andhapur College, where the petition was appointed, it was recognized way back in 1976, very old college. And
what is your prayer in the petition?
Prayer to the extending the UGC scale of pay to the petitioner in terms of the UGC guideline, which has been accepted by the government. If you also will look to my date chart, that will, I think, it was very captured the whole thing.
Date chart.
What are the
Another
copy of our statement.
Tribunal did not agree with your version.
No, you also agree. You also said that is squarely covered. Only
tribunal. You are here because tribunal did not agree with your version.
No. What has happened? The tribunal has not agreed. That which has been subsequently decided in Andhra coordinate bench. Tribunal said because you have received the grant in it after 1489, that is with effect from 1690, therefore you are not entitled to get. But that 1489 cutoff date, which was the subject matter of challenge before this Hon'Ble Court in a writ application, this Hon'Ble Court said that 1489 was cutoff date was ultra vires. But the state went to the Supreme Court in Ashwin Das case. Supreme Court said that 1489 cutoff date is valid. The judgment was set aside, and the Supreme Court categorically said those colleges which have got concurrence and affiliation prior to 1489, that cutoff date is 1489 for the purpose of getting concurrence and affiliation. But here is the admittedly concurrence and affiliation much prior to 1489, so far the college is concerned. But the grant period has been released with effect from 1490. That means after 1489. That
taking that, reckoning that date.
That date.
When they should not have reckoned it.
Your judgment also look to that judgment. That has been decided by this court, by a coordinate bench. Both the Ashwin Das case and that judgment are given, and your page 131 of your worship's that system is 131.
Yeah, just below the mentioned memos.
131.
Yes.
Just below the mentioned memos. There are two mentioned memo, just below that.
Yes, Mr. Monti, what do you say?
That judgment, in fact, I would have.
They had already given.
You just look into, we'll call this matter immediately after vacation.
Sir, second subject.
Let him look into that judgment. Call this matter on 9-10.
Can it be
9-10?
This will be, if that will be covered. My lawyer will say this squarely covered. Let him examine next
to. Tomorrow he will be answerable.
Next to you.
It will have difficulty, sir. Really difficult. Otherwise, I will have posted, of course. Immediately, we call it on 8-10. 8-10.
Monday.
Okay. Okay. Wednesday it will be 8-10.
I have served a copy of the judgment. Also.
That I have received.
Yes.
I have received.
Look into.
I am for the respondents.
Yes.
Appeal has been filed by the state government challenging the judgment of the State Education Tribunal, granting the opposite party, granted 1/3 from the 16/1988, 2/3 after the 16/1998, and full cost thereafter, my lord.
Yes.
The judgment, my lord, on the basis of that circular dated 17/3/1979, on the basis of which the granted has been allowed on the, and also on the basis of two judgments of this allowed court.
Who does Sindamande? Who judgment? Oswita.
Annexure 6, 54, page 54, you will also studies. That on the basis of this judgment, Pratap Chandra died. That's from 55, my lord, passed in opposition number 1986 of 1997, order dated 4/2/1998. Now let me place that small judgment order.
Do you have copy of the judgment with you?
Yes, my lord, I have copy. An extra copy I have not, so with the file, my lord, you will also find. Very old file there, my lord.
Clear.
Say, judgment of Judgment of
54. Page 54. Two orders are there, my lord, based on that decisions.
54. 54 to annex of 2.
To the GI case.
Minimum grant in it from 87, 88.
1988, because while the school was recognized in the year 1983,
5 years will be?
No, 4 years here. In the in respect of as per the circular dated 7/3/1979, you'll also kindly see this circular. I am entitled granted, but the relevant portion is 7. 1 10 1.
Get Xerox of 2 pages.
That book by Martin. Here, my lord, that this court held that, this honor court held that as per the circular dated 17/1990, that was the granted policy prior to 1994, my lord.
Circular dated
17/3/1979, my lord. In respect of the high schools and upper primary schools, my lord. There it has been decided that the school which has been recognized and the first batch appeared in the HSC exemption, if they appeared for 4 years, they are entitled to 1/3 granted, my lord. Here in the Eastern case, the school was recognized in the year 1983 and the first batch appeared in the 1984. And on the basis
recognized when?
1983, my lord. I'm giving that date.
Appellate submits that the school was recognized while order dated.
That file is theory of systems. Recognized by the order dated 24/9/1983, my
24/9/1983.
And first batch of students appeared in the year HSC exemption 1984.
First batch of HSC students appeared for examination in the year 1984. 84.
So on the basis of the sets,
the circular dated 73/1979 provides for the minimum grant with effect from
1/6/1980, 1/3/1980,
1/3/1988, 1/3/1988.
My lord, can I place the impugned judgment which has been annexed, my lord?
That relevant page, relevant page
next page, third page. 10 year term. 2 and third page, relevant page.
First.
Second.
Coordinate bench in OJC number?
OJC number, my lord. 1986 of 1997.
Of 1997.
Order dated 4/7/1998.
Between
4 to 1998.
Pratap Chandra
Gantayat
and others versus state and others decided on
4 to 1998.
4 to
1998.
1998 has held that after 4 years, the institution will be entitled to the minimum grant.
Yes, minimum grant.
Minimum grant in terms of state circular. First, council submits that the tribunal missed this point, and as a consequence, it counted 5 years.
4 years, mine.
No. Tribunal counted 5 years.
4 years, mine.
It also counted 4 years.
4 years allowed it, and that has been challenged by the state government.
This was allowed.
State appeal.
State was challenged.
Accordingly, the tribunal has opponent to the respondent submits allowed the appeal. Where is that order?
My lord, Annexure 4.
Annexure 4, page 76.
Page 76.
Whether it referred to that judgment?
Yes, my lord. Your lordship, I see. It is clear in my view.
After referring to the said judgment.
Paragraph 4.
Decision. OJC 1936 of 1997.
97. That I have referred to Pratap.
Despite submission, when the counsel AGA appearing for the appellant is not in a position to what finding of fact is wrongly entered by the tribunal, or what wrong principle of law is applied to the case. First of all, in view of the above, the appeal is dismissed. The order of the tribunal to be implemented within an outer limit of 3, in letter and spirit. If really proof, the respondents may move an appropriate application for taking punitive action against the errant officials, which may include levy of exemplary costs payable by them from their pocket. Dismissed. Next.
Madam Deputy. In this appeal, the order of the Education Tribunal is under challenge.
Yeah.
Now, we have given a short note for your Lordship's convenience. Now, this is an interstate dispute between the appellant and the respondent number 4. Now, the respondent number 4 filed a GIA case for the second post and for release of block grant that the tribunal has accepted. Against that judgment, we have before your Lordships.
What happened?
This is a private dispute between the appellant and the respondent number 4.
Appellant and respondent number 4.
My lord. So far
as a private party.
Between private parties.
Disputes between private parties is entertainable by the tribunal.
Yes.
What is the powers of the tribunal?
24B.
24B.
24 capital B.
Yeah.
Relating to grantinate.
Relating to grantinate.
Grantinate dispute.
Now, my lord,
dispute between two private individuals will partake the character of dispute relating to grantinate.
Yes. My lord, as per section 24B of the Orissa Education Act, the dispute relating to eligibility, entitlement, payment or non-payment, everything will be decided by the tribunal.
So there may be rival claims, arbitration of factors.
Claim with the management.
Okay. Yes.
Now, if your Lordships would see, we have given a short note which is on top of the brief.
Do you have a hard copy of that with?
Yeah, yeah.
There, notes of submission. No, it's all right, sir.
We'll give hard
copies. They have hard copies.
We'll give hard copies. Today also fresh copy we are giving.
Let him serve a copy.
You had given, my learned friend appears on transfer.
Yes.
Earlier count. We'll give. It's right away there. I'm giving him. It's not that I'm restricting. My lord got it. My lords, now also we are giving for the honorable.
No, I have here. The copy which you tendered to me.
My lords.
No,
for him also we have given.
Yes,
okay.
We have additional copies. Now, as I said, my lords, it's a matter of dispute between the appellant and the respondent number 4. My lord may just see the list of dates, serial number A. I hope my lord got
16393.
16393. The appellant was appointed against the second post. This document is there at annexure 2, page 36.
25, these dates would be important because respondent number 6 was appointed, respondent number 4 was appointed almost 3 months thereafter.
Yes.
The next date is also important. Respondent number 4 is junior, and he was appointed as against the 3rd post. On 17/4/2009,
what is this idea of first post, second post, third post?
So
there is no such post. There is
no. He would. I would request my friend to wait.
And numerically, there is no first post, second post. Only peons are admissible. Only class 4 peons are admissible. I will take you lots.
Now the issue is regarding why, my lords, this dispute arises is the moment the post gets entitled for block grant, then these disputes start coming up. So the college, once it gets into the fold of block grant, then these disputes emerge. So his basic case before the tribunal was that treat me against the second post and make me eligible for block grant. That's the specific case also before the tribunal.
To the post to which you are holding?
Which I was holding, which I am holding. Even today I am holding that. There's an interim order in this FA also. So on 17/4/2009, you may see after so many years, he makes a grievance before the Director Higher Education for adjustment of his name against the second post instead of the present applicant.
Yes.
The next date is also important. Director held that the appointment of the appellant against the second post is illegal and void for the period of 1994-96 and directed the governing body of the institution to pass necessary regulations. My lords, this order of the director was passed under Annexure 1 at page 20.
Under which provision of law he passed that?
That was under the direction, my lords, since he made a grievance, the director is entitled to pass this order.
Under which law?
That I'll have to check.
That as per the Grantinate Order of 2008.
Grantinate Order of
2008. Because this college was notified as per the Grantinate Order of 2008. And when a college becomes eligible or notified to receive grantinate from the state government, the power is entrusted upon the director to verify the documents and to come to a conclusion who is eligible and who is not. That Your Lordship may kindly see Grantinate Order of 2008. That is at page 443 of that manual. My Lord got it. My Lord may kindly come to page 448. Because the dispute started when the college became eligible to receive grantinate as per the Grantinate Order of 2008 and when proposal was sent recommending his name approval. Para 12.
Governing body.
Yes, proposal from the governing body in respect of eligible persons. The governing body of a non-government educational institution notified or which applies for notification of such institution as an aided educational institution shall furnish proposals in regard to the person, this is important, or persons who are eligible to receive grantinate against approved post or posts eligible to be approved from time to time, indicating the full justification of the proposal. The governing body shall inter alia furnish information on the following: the name and permanent address and other things. Then Your Lordship may full particulars of the post against which everything has to be stated. Then Your Lordship may kindly come to it.
This is the duty of the management.
Duty of the management. Then paragraph 30.
Scrutiny by the director.
Scrutiny by the director. This is important. Scrutiny of the proposal by the director. On receipt of a proposal from the governing body, the director or any official authorized by the state government shall examine each case, and if they are satisfied that the person proposed by the governing body is eligible to receive block grant, against an approved post, he shall make an order to that effect, where the director is satisfied that a person proposed by the governing body is not eligible to receive grant in aid, his decision shall be communicated to the governing body. For the purpose of satisfying himself as to eligibility of a person,
so he can hold inquiry.
Can hold inquiry. So this power was exercised by the director.
No, that's incorrect. Now, my lord, may kindly see the order which was passed at Annexure 5, page 23.
No, I asked you, under which rule the director passed this order? Now, prima facie, he has shown.
He has shown, my lord. My lord may see the order itself. That what was read out was the proposal and how the director would decide that proposal. Now, my lord may see Annexure 5, page 23. Because if your lordship would see the list of dates, I had said that the respondent number 4 made a grievance vis-a-vis his seniority and the appellant seniority. And on that grievance, the order that has been passed is at page 23, Annexure 5. May I just show that, my lords, 27/11/2009?
Page number?
Page 23.
Yeah. Annexure 5.
Annexure 5.
Yes.
The director higher education writes to the secretary of the governing body. Subject is matter of dispute in seniority between Ranjan Kumar Datta, who is the appellant, and Siddheshwar Mohanty. And here, my lords may see this letter with reference to your letter number so-and-so dated so-and-so on the subject mentioned above. I am directed to say that as per college record, Sri Siddheshwar Mohanty was appointed as third peon in the college by resolution number so-and-so and joined on the same date. So this date corresponds, my lords. This is what the director says, 25/6/93, and joined on the same date in the college and also receiving his salary from 6/93 till date. On the other hand, Sri Datta was appointed as second peon in the college by GB resolution dated 16/3/93 and joined on 16.
Subsequent to yours?
No, prior to. Prior to, my lords. Sri Datta is the appellant. He joined on 16/3/93. Respondent number 4 joined on 25/6/93.
Correct. Wait, resolution number 23.
My lords. So the respondent number 4 is subsequent.
You are right.
While continuing in the college, Sri Datta took admission in +2 first year in your college as regular student during the session so-and-so and continued till the end of session 1995-96.
During his absence, when he was away for value addition, he appeared to have made the signature in the register. That's what your text says.
Yes. What the director holds that he was himself admitted in your college, and during his study period, he has signed in staff so-and-so and has been paid his salary. Such act on the part of Sri Datta is highly illegal, and this has happened within the knowledge of the principal in charge. Therefore, the appointment of Sri Datta as second peon during the above period is treated as illegal and void. In this event, the GB may pass necessary resolution accordingly.
The next part.
You are therefore requested to ensure the matter and fix up responsibility on the principal in charge by calling show cause notice. Action taken, so and so.
This allegation is made against whom?
Petitioner.
Your claim.
Yes. This allegation was made without hearing me, behind my back, and this was sent to the secretary of the governing body to do this.
Then
what is crucial here is in the list of dates, your lordship would see this. We've taken that specific point that this order was passed without hearing the appellant. This is undisputed. Now, after this, the governing body, my lords, at page 38, passed a resolution again in my favor, saying that this person no doubt took admission, but he was continuing as a peon and he didn't pursue his studies. That was the case of the governing body. Page 38.
You were not heard in the matter?
No. I was not heard in the... Sir, please wait for your turn. I was not heard. So the point that we are trying to make, my lords, is that the tribunal has resorted to this order and has said that since you have not challenged this order, this will be held against you and you would lose your seniority.
When that order was given effect to?
No, this was given effect to on 22/12/2009 under Annexure 2. And the governing body reiterated its stand that I am senior and this period I have not attended the college.
But the fact remains you did not challenge that order.
Yes. I did not challenge. The director's communication to the secretary of the governing body has not been challenged by me. That's a fact. So now the question is, what would be the consequence of such an order? Because my lord may see the dates are very crucial. On 27/11, the director higher education says that this is illegal and asks the governing body to take appropriate action. The governing body thereafter takes action and reiterates its earlier stand that the appellant is senior.
But that action was against the principal.
And it said that because of this, you take action against the principal.
But that fact matrix was kept intact.
Yes.
On the basis of that, you take action against the principal, what the director's direction.
No, but the director also said that your appointment itself is illegal and void. So now the point that we are trying to make, my lord may just see in this inter se dispute what the tribunal holds at the impugned order begins, my lords, from page 40. That would be PDF page 106. If your lordship is taking PDF, otherwise annexure 4.
Annexure 4.
Annexure 3, my lords. I'm so sorry. Annexure 3, page 40. That is the impugned order. And the relevant portion which has been held against me begins from paragraph 6, page 43.
Yes. From the order of appointment.
From the order of appointment of both the applicant and the OP number 4 under Annexure 3 and Annexure 4 respectively. Here the numbers would change. Applicant would be respondent number 4 before the tribunal and OP number 4 would be the appellant hearing. Against the third post on 25/6/93, whereas so-and-so was appointed against the second post on 16/3/93. On the very same day, both of them joined in their respective forts. From the letter of the Deputy Director, NGC so-and-so, 27/11/2009 under Annexure 5, it appears that OP number 4, while continuing in the college as peon, took admission in +2 first year in the same college as regular so-and-so. During his study period, he had signed in the staff attendance register and paid his salary. The aforesaid act on the part of OP number 4 was not only illegal, but the same happened to be... So the same thing has been reiterated in paragraph 6. Para 7. Though the OP number 4 claims that he was only admitted in the college but never attended the classes, but failed to rebut that he did not get admission in the second year and continued his study from the session so-and-so. That apart, OP number 4 failed to file any documentary material to establish that he has challenged the order of the Deputy Director under Annexure 5, where his appointment has been treated as illegal and void and the said order has been unsettled. So this is the paragraph that is being held against us. Now, in this backdrop, your lordship may kindly take up that the judgment which we have given in our note. My lord, that would be, my lord knows that Sulochana Devi. It begins from page number 19 of that hard copy note which we have given.
For the proposition?
For the proposition that if an order is passed without hearing someone, then that needn't be challenged. It is non-est and that need not be given effect.
take down AR 9. Kindly read this judgment.
My lords, we have given copies to my lords.
Contrary decision.
AR 1992
My lords.
SC 111 paragraphs 5 and 6. Kindly read that.
Even if void orders are required to be challenged. Unless declared.
Where Apex Court 3 Judge Bench referring to Professor Wade and Forsyth. You can read it from there only.
So we have this, I haven't gone through that judgment. So if
It
you're
answers that question against you. Identical facts. They said my termination is bad. It is non-essential, void ab initio. Therefore, I need not challenge.
So that is something, my lords, which in 2005, the Honorable Supreme Court itself says that, my lord, may kindly see paragraph 23 and 24.
How many?
Of course, I must say that, my lords, that judgment which your lordship said, that I have not gone through.
And 2011 judgment. Justice, Honorable Justice B.S.
on both sides.
B. Sadasiva.
My friend may wait for his, my lords, this is something which is unthinkable. I have not completed my points and for the appellant.
I'm not disturbing.
Yes, then, my lords, this let my friend continue. I'll give my read.
I'm not disturbing.
This is unfortunate. I have not completed.
Anyway,
I have not been able to show my judgment.
Or 21.
Yes.
Then, my lords, may I suggest something, my lords? I will take note of.
This judgment refers to the judgment which I said.
Yes.
That judgment is reported in 2 volumes.
Yes.
The Supreme Court has referred to AR 1991 SC 2219.
Yes.
I said AR 1992 SC 111. Both they are same judgments.
Yes.
Write down.
Yes.
Just look.
This judgment also, I'll write down. The judgment which is also a Supreme Court judgment. I'm not relying on any High Court judgment.
Saying how many judges? When it is rendered?
This is 2005.
How many judges?
2 judges.
That's the problem. The judgment which I quoted is by 3 judges.
Now, here, then, my lords, the other question would come up that order which is inter se passed behind my back only is a recommendation. That recommendation has been acted upon by the governing body. The governing body has reiterated its stand that I am senior and has factually stated that I didn't attend the classes. And then the judgments of this honorable court come in, which say that it is the governing body who is the final arbiter of seniority. The state education tribunal cannot adjudicate these seniority disputes. Those judgments of our High Court also are a part of that compilation which I have given.
Now, pursuant to direction of the director, the governing body looked into the matter.
Yes.
And reiterated its stand. Contrary to what was proposed by the director.
Yes.
Is your case.
Yes.
In other words, you are putting forth 2 contentions. That is an intra-departmental communication, which is not addressed to me.
Yes.
Therefore, it cannot be treated as an order against me.
Yes. And there I was trying to put forth the Supreme Court judgment, but even if that goes against me, the other point comes in. And then this aspect would cut both ways. Then the order of the director, which has been, I'm sorry, Malas, the order passed by the resolution passed by the governing body, pursuant to the order of the direction, has not been challenged by the respondent number 4. So this proposition would cut both ways. Then that resolution also is staring at them. And the judgments laid down by this honorable court say that so far as seniority is concerned, it is the governing body which would be the final arbiter of this dispute.
Whether it is a matter relating to seniority or appointment itself.
Seniority itself. Seniority for the purposes of granting it. That's why, my lords, the dates are all important. The present respondent number 4 kept quiet for so many years. There, my lord knows, with my lord's vast experience in this service branch, that you don't challenge seniority quickly. You cannot sit tight over the seniority aspect for decades. Now 93, 94 I am appointed. You challenge it in 2009. When the college comes into the granting aid fold. So this entire issue is vis-a-vis granting aid. And this, my lords, has been frowned upon by courts, that seniority is something, if you don't bring it to the fore quickly, you lose your chances. And here, my lord may see that dates are staring at him. All appointments made are in 93. 2009, the first grievance comes. That's almost after 16 years.
On that, what the tribunal says?
Tribunal has not gone into this. Tribunal is swayed away only by the order of the director, which is passed behind my back. And I read out that order of the director. It is an communication, inter se communication, not deciding on the proposal of the management regarding granting aid. It is on a grievance made by the present respondent number 4. So
anyway, it is not an order against you at all, is your contention?
Yes.
Because you were not addressed at all.
My lords. This judgment of the Honorable Supreme Court is what I was trying to, but I do concede, my lords, this is something which, as an absolute proposition, there are judgments both ways. But this judgment does
in fact, Gurdayal Singh,
my lords,
which Hon'Ble refers to.
Yes.
Gurdev Singh. Their illegal orders of termination were issued. They were issued to the employees. But in your case, it is not in the nature of an order. It is in the nature of a recommendation to the board of governing body to take action. Where is the proof that this order was served on you? Mr.
Yes.
Swain, where is the proof that this order was served on him at any point of time?
My lord, for my learned,
just I want to
one aspect only. This order was a recommendation to the governing body.
Recommendation. This is an order.
Anyway, yeah, you may.
Governing body thereafter passed the resolution reiterating that I am senior.
That becomes order is in your contention. But order he has not challenged is your contention.
This cuts both ways. Governing body resolution. So far as the resolution of the governing body is concerned, it is never communicated to anyone. Because pursuant to the decision of the governing body as per the management rules of 1991, the secretary, who is the principal executive of the governing body, he uses to communicate the order. By simply passing a resolution without communicating the same to anyone, the question of challenging the governing body resolution does not arise at all.
That contention avails to him also.
Well, no, your lordship may kindly see. So far as the order of the director is concerned, well, here what my learned friend has argued before your lordships, that I slept over the matter for a long period, and in one fine morning, I rose from the slumber and claimed for seniority. That is not correct. Here, admittedly, he was senior, and I was appointed subsequent to him. But the question arose why? She took admission in the same college in +2 classes in 94-95, and he prosecuted his studies in that college from 95-96. That is the findings of the director. And for that period,
since not have been in the employment,
and there is a direct judgment of our own High Court that has been confirmed by the Honorable Apex Court. Your lordship may kindly see that.
But he never attended the classes.
But he never attended the class. He attended the classes. Now since the governing body is siding him, governing body is saying that he has not attended the classes. But registration number was also issued to him. Your lordship may kindly see my counter.
My lord, you have to leave me today. I have some work which in so many matters I have disposed of. I have to finalize. And by the time I go home, it will be almost 8 p.m. or sometimes it crosses. Now, a rough idea, I got this.
And there is a direct judgment of this Honorable Court which has been confirmed by the Honorable Apex Court. In that case, what has happened, and incidentally, I was the lawyer in that case, and I succeeded. But the person concerned, he was a lecturer in that college. he took employment as a Sikhya Sahai. He got the employment, he got the appointment order of Sikhya Sahai. He never joined. My lord, he took a plea, like this case, that I never discharged my duties as Sikhya Sahayak. Uninterruptedly, I have worked as a lecturer in the said college. So how my appointment will be affected? This honorable court held, Your Lordship may kindly see that judgment. It pinches the shoes.
If it's an unreported judgment, either a copy may be given or the reference may be.
Yes, yes. A reference from
You share a copy also with your friend.
Yes, yes, I will.
So that after,
I will
he
say.
come
I will
after
say.
reading.
I will say. My lord, I am not. My lord,
Did I give?
don't. My lord, may kindly come to page 21 of that judgment. Point having been raised, the second paragraph. Point having been raised, even accepting for a moment that the appointment of the respondent number 5 was valid and lawful, the documents reveal that respondent number 4 was appointed as Sikhya Sahai and he had joined in Radhakant Nodal UP School on 18/7/2007. It is further stated that since he remained absent from that date, very day onwards, he has not been paid his remuneration as Sikhya Sahai. Admittedly, this fact was not informed to the college on the next day, that he was no more interested to work as Sikhya Sahai, and although joined, he is not working or has abandoned the said engagement. It is also not stated that he resigned there as Sikhya Sahai or to have expressed before the authority his disinclination to have been in that engagement, nor he has asked for withdrawal of his resignation. In view of all this above, I am unable to find as to how these facts are doubtful as held.
Yes,
the
sir.
day he joined as Sikhya Sahai, my lord. And this has been confirmed by the Honorable Apex Court.
Very good. One more question. Just
Yes.
I'm not deciding this matter today, but just since you cited that question,
Yes.
Whether you received the salary for the period during which you claim that you were in the employment?
Yes, yes.
Illegally received.
No, illegal.
How it reached your account?
Yes.
Is it paid by hand or it went to your bank account?
Those instructions I'll have to get, but that was 90s.
Very well. The bank,
90s.
no,
94, 95 and 95, 6.
Every
94, 95 and 95, 96.
every employee will be paid the wages
My lord.
by crediting it to your bank account. Whether during that period, the salary was credited to your bank account.
During the study period, the finding of the director is, during his study period, he has signed in the staff attendance register and has been paid his salary.
That is illegally.
No. So these kind of, such, so this,
That's me.
Yes.
You ignore that your friend
So-
is standing beside you.
the finding is that I have received salary and I have signed on the register. And this was 93, 94.
No,
where these
94, 95 and
this is
95,
unfortunate.
96.
But this kind of, I don't know.
No, you are-
Then, my lord,
you are
let
saying
the friend
something
complete.
incorrect.
Then I would, my lord, have my, let him complete.
Mr. Swain, I request you, wait. I'll give you an opportunity before I make any order.
Yes.
So, my lord, these dates are important. 93, 94, he has signed on the register and has been paid the amount that the director himself holds.
No, it was paid how? So how rest of the employees, how payment was made by the college? Let us see.
No, that aspect is something which we will have to get in how others work.
Now, who pays for the management? Just you're standing looking at the calendar, how it will help you.
I supported the
Now what support? How were you making the payment of salary to all the employees during that period? This is a very good. Tuition. On being asked during the relevant period, that is 1993 to.
So this is 94, 95 and 95, 96. He took admission during that period, not 93.
Period 1994 and 95 and 95, 96. how salary was being dispersed to all the employees, including the appellant here, Rama, answers that, says that he has to secure the information and time be granted. First time. On the next date of hearing, the institution shall furnish this information after serving copy thereof in advance on the learned counsel appearing for the appellant and the copy number 4, copy number 4, spelling which heavy costs may be levied on the management. Okay. All this matter in the on 1410. 1410. In the meanwhile, just look into those judgments.
Yes.
And whether that intra-departmental communication constitutes an order. What is an order is said by the Supreme Court.
Yes.
I think in EP Roy or some EP Roy fight, maybe 74 Supreme Court 555. Yes. When a communication partakes the character of an order, that is also there. That apart, there are judgments where it said unless an order is communicated to the party, it is no order at all.
It has no effect in the.
It is no order at all.
Yes.
Because the order has to see the sunlight.
Yes.
Otherwise, it will against whom it will. You will pass order and you will keep it in your drawer. How I will come to know?
That is not the case here.
No. What is the case we will show, Millet.
And see,
the interim order to continue.
Interim order to continue.
I'll see all the judgments, also the one which my learned senior showed against me.
That judgment and that judgment refers to that Gurudev Singh.
Yes, and Gurudev Singh also we have noted.
Yes, it's a 3 judgment division.
3 judge, this is 2 judge.
2 judge. If there is variance between 2 judge and 3 judge, what we should do? Unless the 2 judge refer to 3 judge, there are principles.
Yes,
just look.
Here, in fact, against me, this Gurudev Singh has not been noted by Justice Lakshman here. So that is the point against me. But I'll examine this, and also apart from this, the other aspects are also there. I'm grateful to you. Interim order to continue.
Interim order to continue.
My lord, may fix it any date after.
Yes, 14th.
Great.
Yes. Yes, rest of the matters you have to wait till vacation is over.
Supplementary matter, item 60, Item 60. In suffering the acrimony of this matter from 1920, it was there before my lord earlier. There was an adjournment taken on the ground of the bereavement in the family of the petitioner. Subject to pleasure of my lord, fix it any date, my lord, any date suitable to my lord. Sometime next week, my lord. It's a very short matter, my lord.
Next week we have decided
not to
take only urgent matters, because only 1 week.
Very well. I'll leave it to your lordship.
That's the reason. Kindly choose some other days.
My lord, we
from the calendar, whichever date you may choose.
Whichever, my lord. 9th, my lord.
9th. Serial number. Just listen.
Well, if it go 13 2 weeks coming to 13.
13.
54.
13 is next.
13. 13 to
October 13. 13, not 13. We'll take 1 day or 2 days after, because that will be reopening day.
Then
I have to do a lot of exercise to face all of you.
You have 8 mile. Your after capital 14.
14.
My lord, item number 55 and 57. My lord, let it come on 16.
16.
My lord, serial number 212 weekly list, my lord. The covered matter, my lord. Serial number 212,
212. Which date?
My lord, tomorrow that will be taken up.
Covered by judgment.
Covered by Little case, my lord.
Covered by judgment. Covered by judgment.
Yes, my lord.
Covered by which judgment?
Your lordship's order, my lord.
Just need not wait. He is saying covered by. Just I'll look into whether he is. You need not wait, sir. Yeah. Take that. You were senior to the other.
Yes, madam. I'm senior, madam. I will have to reserve.
Only appears for the piece.
Nobody has.
No, Milord, it is in the weekly list 200 something, 212 as my.
Yeah.
Up to 100 it has been allotted. Then the file has to be called for.
We will shift it to daily list.
Yes, ma'am.
If it is covered.
Yes, ma'am.
Shift that matter to daily list and call it on 10th of. October 10th. 10th of October.
10th of October.
Yeah. Shift it to daily list because he says it's covered by the.
But then it can be verified.
Verified. That's the reason.
Item 59 matters.
59. What is that matter, sir?
That is regarding the period, my lord. I am for the opposite party. I have the petitioner.
You are the
petitioner. That is the period of service, counting of the period of service.
Okay.
That he was terminated, my lord. I was attached to the inspector school's office. I am a teacher, trained graduate teacher. Pursuant to direction of this honor court, he was adjusted in another school, my lord. But the period during which he was terminated, my lord, I have worked for that period. That period, I pray that period may counted towards my service.
I pray that period should be treated as I should be paid.
The same period should be treated as working period for you.
Yes.
That is the dispute, my lord.
Still, at any other date may come.
On 15th October, my lord. I have one prayer, my lord, in weekly to 161 items.
161. Yes. This is in 161.
No, it is 59. Weekly one item.
59. 2011 matter.
Yes.
Yes, on 15. 16.
161 in weekly list, my lord.
161.
Yes, my
Which year?
Of the year, my lord. Only 1 second, my lord.
Now, weekly list we have released only to keep everybody prepared.
My lord,
then we have to shift them to the daily list, actually. That is the object.
Actually, 2024 matter, it has been started in the year 1995. 93, my lord. 93 matter. A number of times this case had come to this honor court, my lord. At length, it was remanded to the
shift it to daily list. We'll shift it to daily list. Yes. The same day you put it.
On 16th, my lord, or 16th? 16th.
All right. Okay.